Yeah, how are you? Doing well.
Hello, everyone.
Brandon, that's fine.
So 2019.
It's been a long time.
Ange, did you do all the settings for
Like,
Yeah,
Zoom?
it's just
Yeah.
for closed captioning and recording, so we should.
Okay, so I mean you turned on the close and you turned off chat, right? And questions and answers, right? That wasn't activated.
Oh my gosh. People.
It doesn't look like it is. It looks like, let's see, let me see.
How's it going?
Panelists can chat with blah blah blah. No one. Okay, no, you got it right. Okay, cool, perfect.
No, it's so cool, weird. Yeah.
And I'm like, I don't remember what floor the state bar's on anymore in this building. Like,
Yeah, I know. And we'll probably all get
So long.
COVID today.
Oh, that's the spread.
either that or monkeypox, right?
Yeah, seriously.
Erica, it's nice to meet you.
Very nice to meet you as well.
Surprised they didn't put us in the big conference room though.
I know,
Social
strips us out,
distancing.
right?
Yeah.
This will come in handy for whomever.
Oh, yeah, I'm sure.
I think that we thought like the public, because they're not used to seeing people in a room, we're usually all labeled with their little.
Yeah, that's true. That's a good point. We're not quite getting started, right?
And you gave Erica some voting slips?
Yeah.
Okay.
How was your trip, Mimi?
It was good. It was
Good.
fun. I ate too much food, like way too much food.
That's what you do when you go to like other countries that have good food.
Yep. Because you can't get food like that here. Hey, where is? Why is it not open?
Created our security because my laptop, 2 times I've come here, won't connect to the state phone.
Really?
So I get stuck to do what's up.
Because of all the stuff that you guys have done.
I guess so.
You guys keep it up with the firm?
Apparently, not messing around.
It's like, that's so funny. Is there a cord that you can drop into the Tesla or not?
Let's see.
Or do we have one on your knee?
So this is all unplugged.
There's this one that we can maybe slide over.
Okay.
Slide.
Are you gonna, I mean, I can.
We're almost
Oh,
there.
that's it.
I think we're there.
I mean, it also, once it charges, look at that, actually, works out pretty well.
And I think we need one more for a quorum. Is it one more?
1, 2, 3.
I'm gonna run out.
5, 6, yeah. One more.
Did you fly to SFO or Oakland?
I went to Oakland and saw some friends yesterday.
But everybody who was supposed to attend in person has arrived. Are we missing anybody?
No, everyone's here that should be here in person.
Okay.
I was just in New York. And it's
So we're waiting for Kyla, Hunter,
1820.
Toby.
Just busy as everything. It's crazy. So
That should be everybody.
Culture here is just.
Kyle, Hunter, and Toby for sure. Ken maybe.
yeah, we're all the little supporting.
Oh, there we go. We got Toby.
We have a food court in my building. It's would support and did support 6 restaurants. One of them is open out of 6. It's really sad.
It's terrible.
It's really sad.
Wow, I'm just so surprised. I guess I've been up here since 2019. It's a big difference.
Yeah, it's a ghost town.
Did you have Skateland in Orange County? Remember something called Skateland? It was roller rings, big in the 80s and 90s.
Okay.
So I grew up in San Fernando Valley. That was a huge like hangout place. And I was just reading an article yesterday. COVID just decimated the Skateland business, and all those little roller rings are all gone. It's just a different.
So LA has gone to street dining, but it's still pretty busy. It's not, it's different. LA's like that, and then Orange County, everything's outside, and plus half the people pretend COVID. Yeah, so they're on Indeed.
in San Francisco. It's worse now because of all these little nooks that took over the parking spaces where people now dine on the street.
Oh, man.
But the
Alright.
bigger lots are like, probably still fine, right? I mean, I don't drive, I mean, I just took part.
Oh, parking lots are fine, but I mean, like, you're trying to find street access on like.
To go to a
Fort
restaurant,
Walton.
yeah, I hear
Oh,
you.
nice, yeah.
Fortunately, Little Star Pizza is still in business, which is, that would have been real hard for me.
Aren't they visitor already? Yeah.
Maybe it's just me, Ange, but I don't see any files in the July 29th folder. Did you save it somewhere else? Maybe I need to update my computer.
It's in there, maybe
So
you're not
everything
seeing.
that we're saying is coming up on that thing.
Yeah, we're at, I haven't pressed record, so,
Okay.
yeah.
So like you're coming up with, so I'm like, why is Little Star Pizza? Okay. I
Now the
just,
world knows.
not that I'm gonna say anything inappropriate, but it's a good reminder.
Everyone's
It's so
watching,
funny.
yeah.
I don't think I've ever tried to view CoPrac during a CoPrac meeting, there'll be like 2 people.
Oh, really?
You're one of the 2 as you log on.
So it looks like everyone is here. Do you want me to start the meeting?
Yeah, let's get going.
Okay. Good morning, everyone. We have a quorum and we'll start the CoPrac meeting. This meeting is being recorded. Before I do roll call, we ask that if anyone wants to give a public comment, to please use the raise hand function and let us know if you'd like to do so. So with permission from the chair, I'll take roll call.
Please do.
Justin Fields,
Here.
Ken Bacon,
Here.
Sarah Benola, Elizabeth Bradley, Cassidy Shivers. Here. Toby Enlander,
Here.
Brandon Krieger,
Here.
Joel Mark,
Here.
Eleanor Mercado,
Here.
William Munoz, Dina Roche,
Here.
Kyla Rowe.
Here.
And Hunter Starr.
Here.
Thank you.
So do we have any public comment today?
We have no public comments.
All right.
And just make the announcement one more time, just because a lot of these people did not connect until after you made the announcement.
Okay, got it. So if anybody is listening from the public right now, if you'd like to make a public comment, please use the raise hand function so that we can let you speak. Nobody? Okay.
All right. Why don't we, unless there's something before that, why don't we move to staff report?
Okay, good morning, everyone. First of all, let me introduce myself again, because I think the last time I was at the meeting, I was just kind of sitting in. So I'm Erica Doherty. I am the new managing attorney in the Office of Professional Competence. And as staff attorney to CoPrac, I'm filling Andrew Tuff's gigantic shoes. So I'm happy to be here and bear with me. So a few quick updates from the Board of Trustees meeting that occurred a week ago, I believe. So first of all, the board approved new CoPrac members who will start at the October 14th CoPrac meeting. That includes Raquel Brown and Daniel O'Reilly as new members. And then Sarah will serve as chair, Brandon as vice chair, and then Justin, you are going to be the new advisor. A few other items. The Board of Trustees also approved moving from Robert's Rules of Order to Rosenberg's Rules of Order, which are a simpler version of Rules of Order that hopefully will be implemented. They've approved those, but they're not going to be in effect yet, so it's going to be in the next couple of months once the Board of Trustees policy manual approved. And then finally, also at the Board of Trustees meeting, the board approved proposed amendments to comment 1 of Rule of Professional Conduct 1.4. And the next step for that is to go to the Supreme Court for approval. And they also issued amendments to Rule of Professional Conduct 1.15 for a second round of public comment for 45 days ending on September 10th.
Great. Well, thank you, Erica. We're very excited to have you. And Andrew played an integral role in this committee for such a long time, and it's really great to have someone here permanently to take the lead for the state bar in the shoes that you're going to fill. So thank you very much. We look forward to working with you. So I think up next is a approval of the open session action summary from last meeting.
Okay, do I have a motion to approve?
Motion to
Andrew, in a second.
Second.
All right, I will take vote for that. Justin Fields,
Yes.
Ken Bacon,
Yes.
Sarah Benola, Elizabeth Bradley, Cassidy Shivers,
Yes.
Toby Inlander,
Yes.
Brandon Krieger,
yes.
Joel Mark,
Yes.
Eleanor Mercado,
Yes.
William Munoz, Kyla Rowe,
Yes.
and Hunter Starr.
Abstain.
Abstain. Okay, the motion passes.
Great. And can everyone hear us? I know that I don't know where the microphone is relative to where we're sitting, but if you have any trouble, let us know and we'll adjust the room as
No,
necessary.
it sounds good. I was just thinking to myself, wow, I can hear everyone really clearly. So,
I can as well.
Well, we're excited to have our first partial in-person meeting here. This is kind of cool. We haven't had 4 COPRAC members in a room together since I guess January of 2020.
February of 2020, yeah, one of those.
It's been a while, so it's great to see some new and familiar faces. And thank you all who are here remotely, and hopefully when you're able or comfortable, we can all see each other in person sometime. So just as a housekeeping matter for this afternoon, Bill is tied up until the afternoon, so let's plan on moving the succession planning opinion to discussion after conversion clauses. So we'll do the proposed amendments regarding civility and cryptocurrency as the after succession planning. And that'll give him an opportunity to hopefully attend to talk about his portion of the proposed amendments on civility and cryptocurrency. We're about 23 minutes ahead of schedule already, so we're doing a great job here. I also wanted to flag that towards the end of the meeting, we have some time devoted to a new topics discussion. And so to the extent you have an opportunity between now and this afternoon to think about ideas or concepts you'd be interested in exploring, it would be welcome to have a discussion on any of those ideas or concepts, because I think we're at the point where we should start talking about getting another opinion in circulation. I think it's great that we're moving forward with the in-house counsel opinion and the cryptocurrency opinion, but I do think that we have space and time to start thinking about other ideas. So I just want to put that on your radar as we work through the meeting as something to consider. Anything else from folks in the room before we get started with our first opinion? No? Okay. So on tap first, we have 19,004 client file release and retention duties. And I believe where we're at, and I think Hunter, you're probably going to take the lead in refreshing us, is there were some revisions made based on our last discussion, and we were going to talk through those revisions. And then hopefully, if we're all in consensus, send this opinion out for a second round of public comment. So with that preface, Hunter, maybe you can walk us through what's been done to this opinion since the last time we discussed it, and then we can have a discussion about those revisions.
Yeah, sure. Thank you, Justin.
Can I make one point of clarification before you get started, Hunter?
Sure.
Just that I think this red line version shows the changes that we made last time and that people already talked about, right? So this doesn't just show that compare version where we only made changes to the issue thing, right? So I think it might be confusing to people to think like, oh, these were new changes we made from the last time we discussed it to now, because there's really only the changes to the issues, right? I just want to clarify that with Hunter and Ken so that we're on the same page. So obviously if someone has a question about any other part, of course, we'll talk about it, but just to avoid confusion between the members that this is reflecting changes that were already made and we already talked about at the last discussion.
Sorry, just a clarification on the clarification. Are there any new edits to this document from the prior revisions?
The only new edits, and I want Hunter to confirm this, the only new edits are to this issue section and changing the questions, the phraseology or whatever, the phrasing of the issue questions. The other stuff, that's why I wanted that comparison version, but that didn't get into the agenda. This shows changes that we made, I don't know, 4 months ago, and then already discussed at the May meeting, and then once we discussed it at the May meeting, we said, hey, let's talk about how to describe the issue differently so that we can encompass like materials that relate to prosecutors, because they don't have client files in that discussion that we had, but the other things were things that we already discussed. So is that your recollection, Hunter?
It is, Dina, and I appreciate that because I wasn't at the June meeting. So the last meeting I was present for was actually the May meeting. And we did go over a number of the changes then. The primary concern has been phrasing the discussion such that the changes that we are looking at, the changes that we've been asked to look at, are pertinent to the opinion. And when we talk about client cases versus client matters versus client files versus what is a client, those phrases make it difficult to be universally applicable to maybe non-litigation or prosecutors' files. And so the primary difference is going to be that we're phrasing the issue so that it's broad enough to apply to closed client matters, and that would include prosecutors' files with regard to their new obligations with regard to file retention for post-conviction discovery. And the differences are in the issue statement. The ethical obligation of lawyers with respect to retention and destruction of files in closed civil and criminal matters. We're going with destruction of files as opposed to necessarily client files. And we're going with closed civil and criminal matters to avoid reference to just litigation, because there may be matters that are in a attorney's possession that aren't, I mean, they never come up, right? Maybe somebody goes and visits a lawyer because they anticipate some kind of case being filed that is never filed. That attorney still has that closed client matter. So that's pretty much it was really more of a tweak to make sure that the issue statement was applicable to the opinion that we had drafted.
So other than the phraseology in the issue section, is there any other edits, whether old or new, that you feel like you should highlight for the committee before we have a discussion about the issue section?
No, to my recollection, essentially, I just went through and tried to make sure that the language was consistent throughout, so that we're not referring to former clients because they may be current clients, and tried to streamline and make all of those things consistent with our issue statement.
Okay, so then does it make sense to you, Hunter and Dina and others, that we first talk about the framing of the issue and wordsmithing that, and then once we're comfortable with how the issue section is framed, we could then open it up to a discussion about other sections to the extent folks have further comments?
I think that would be the best course of action.
I agree, that makes sense to me. I just was wondering, Mimi, if you could do a comparison from the last version, because these reflect changes that were made in like February. If we could do that comparison from the version that we last had in February, accepting all those changes, you know, the one that came out of that last meeting, and then comparison with this. And we did that version, and I think the only red lines were in the issue section. I just think it's easier to see it like that, but otherwise people can, you know, obviously we can revisit any issue, but it was a little confusing, I think.
Is that something, Mimi, that we can do on the fly? If not, we could get going with a conversation if you need a couple minutes.
I'm trying to access it. I'm looking at the files. I'm sorry, I wasn't here to do this. Give me a few minutes. Why don't you guys discuss the issue section while I work on the revised red line?
Yeah, so while I guess I can kick it off here. I had one question, comment based on what you said, Hunter, that we were trying to sort of have broader language to encompass the different types of files or materials that are then discussed in the rest of the opinion. And so it struck me that we still use the word or the phrase client files in the issues. And I don't know if that's a carryover that we meant to delete, but do we want to say in the red line, it says destruction of client files and materials, or do we just want to say files and materials? What is more consistent with the approach that we've tried to take in revising the?
I think completely removing client might make it more confusing for those attorneys who their files do apply to clients, because there may be files that they have that are not related to actual matters. And so this is kind of why we've been vacillating on this issue. I don't think that there's anything bad about keeping client in there.
Yeah, so, and maybe this will be clarified once we get the comparison. I'm just looking at the first, or excuse me, the second and the third sentence, mindful of what you said about the purpose of the changes, and my concern is that we're not being parallel in how we're trying to broaden the language. And maybe I'm misunderstanding, but in the second question in the issues section, it just talks about destruction of client files. And then in the third, it's talking about destruction of client files and materials. And I'm also wondering if these, the second and third questions are somewhat overlapping or redundant, or did we intend to delete the second question and only have the red line? I'm not entirely sure, based on what I'm seeing on the screen.
I think the intent was to have just the single broad issue statement or the single broad question.
Meaning the red line would become the only statement in the issue section and we cut the first two questions?
That's my recollection.
All right. Is that what other folks remember?
I think that, well, I personally like the idea of the one question, the way you kind of, you talked about it last time, where I think it's easier because you made that point, Justin, which I agree with. But I think we need to add, if it's where this part that says Justin with this colons, we would need to add destruction of client files and materials to that phraseology in the very last point, and then get rid of the first two. But
yeah. I
still think it was, I'm not sure that the committee as a whole, what their view about whether it should be two questions or one question. So I think it was still open for, we were gonna discuss that more.
Okay.
That's my recollection. It's hard when it was a little while ago.
Then I tripped down memory lane. Yeah, no, and this is all, it's all coming back. It does seem like maybe the intent of this revision was such that that third question that's in red line would become the issue, because it seems to encompass at least the second question, maybe also the first. But what does the committee think about this? Meaning whether to just make that third redlined question the issue, and cutting the other first two questions, or some combination thereof.
We need to add
And-
attention to that third question. Right.
Do you want me to pull up the?
And did you get my message?
Yeah, I did. I'm going to go over that instead.
I mean, sure, if you guys can just do that.
We have it. So.
Okay.
Yeah, attention.
And pull up the revised red line that I saved in the folder.
Okay, I have it.
Sorry for the confusion about that.
Oh, no problem. Okay, there you go.
Does that look more correct?
Let's just go back to the other one, Angela.
As someone who forgot his glasses, I'm gonna move closer to these.
I think I feel like I've made this more confusing. I think it's just for the purposes of the committee. we could, a lot of the red lines that are in the body of the opinion are things that we've already discussed. Again, we can review them.
Right, and the version that I just created and saved in that folder accepts, like, for example, in the digest, in the version we're looking at now, there's revisions, but in the revised red line that I just created, it doesn't show that because that was changes that was made from the previous May meeting. So basically that should not be showing up.
Okay, I think it's easier to work off this version because we're only dealing with the issue section, and I think for the most part, we have the information we need, we just need to agree on what the issue is gonna be. Sorry for the confusion.
So just as an initial matter, to start revising this, Tina's right, I think we need to capture the retention concept in that third red line sentence. So Angela, where it says in red line, whether the ethical, that'll be the last bit. Does a lawyer have with respect to retention and destruction?
Well, what about where it says Justin at the bottom? What are the ethical obligations of lawyers with respect to retention and destruction of, and if we put client files and materials in closed civil and criminal matters, does that?
Yeah, or we can put it there.
Yeah.
And then it'll be just a updated version of that other.
I mean, it could be ethical obligations of a lawyer or lawyers. I think lawyers is good because we're talking about different types of lawyers that have different roles, like whether they're a prosecutor or, but I think either is fine.
All right, so what Angela just revised is basically intended to update the language that's directly above in the red line of the first paragraph. And I guess the idea is that this phrasing would become the issue as stated in as stated here, and we would cut everything else. So how does the committee feel about that? Is this one sentence sufficient to capture the issues that are then discussed? Do you feel like it's missing something? Do you need more than one question? Are you happy with this phrasing? What do you all think?
I like the one question, as it's the only thing I would add to it is so it would track 1.16, whatever it is, E1. It's files, materials, and property. Because there are things, that are like evidence. I know in our warehouse right now we have like 5 motorcycles from cases. So.
I think that's a great point.
It also captures portions of the opinion, so that's well taken.
Just take out that first stand, yeah. There we go.
Yeah, nice addition. Thanks, Ken.
I think that works well.
Other thoughts or comments on this updated phrasing?
Justin, did we have a footnote that discussed our reference to client files? Yeah, we did, footnote 3. Okay, thought we had that in there.
Yes.
Yeah, I think that's a good addition, Ken. I was realizing looking at E1 that it really references client materials and property. That's sort of the phraseology. It doesn't even talk about files. I know we had this conversation now, it's like coming back to me, but I think it's appropriate for the reasons you articulated. Hunter to mention files, and we talk about files, and that's a common thing that lawyers are familiar with.
Can we move that footnote so it's earlier in the opinion?
Footnote 3.
Yeah.
Maybe immediately after the issue.
Wherever we first talk about clients. Right now, it doesn't show up until like page 3 of the opinion.
So I guess the first time we talk about clients is in the digest. I guess, I don't have a strong feeling, but would you prefer to start footnoting things in the digest or wait until we actually get into the statement of facts? I'm thinking footnote in the digest might be a little unusual, but not.
That's kind of weird.
But we could also put it first thing in the statement of facts when we first start talking about clients. So maybe we just make that decision first. Do footnote in the digest or footnote in the statement of facts, and then the answer will flow from there where we put it.
I vote for digest.
Can you put it in the issue? Right up front, aren't you gonna say client files and then put a footnote after client?
Okay, that's another option. Option C. All right, so we have issue, digest, and discussion section. So Cassidy's in favor of the issue section, placing this footnote. Jules suggests the digest section. Any other strong feelings here?
I prefer issue.
I
Issue
prefer the
section,
first
we're good
option.
for issue.
Yeah, because that's where it first pops up, so, yeah.
I can live with issue as well.
All right, well, we're moving towards issue. All right, look at this consensus.
I'm
voting.
just gonna say though, that is a little bit unusual for there to be a footnote in the
Yeah.
issue section.
That's the counter reason.
But why?
I
What are the rules?
there are
What
no
is Rosenberg's rules of order say on that?
There's no hard and fast rule about it. It's just unusual to have a footnote from the very beginning. It's kind of, it's fine. I'm not saying you can't do it. I'm just saying it's not a typical practice of ours.
So issue is first glance, and then we get into the dense substantive stuff in digest. So I'm reversing my arbitrary vote.
to what?
Mhm.
To digest. Okay.
Digest. I don't think an issue, but I'll be flexible on either digest or the body. I guess we first reference it in the body, is that correct? That's where it currently stands. The
Yeah, it's
question.
An issue is just usually just a question that we throw out there. It's not like anything is being
We don't need
discussed
to
or
define it.
analyzed there.
Yeah, I get a little nervous if we need footnotes to explain our issue, which theoretically we want to be as clear and clean as possible. So, I mean, I think.
I'm gonna vote for body then.
Is anyone gonna throw stones at me if we move it to the digest for present purposes?
Well, no one on the video screen is gonna throw.
Yeah,
stones.
virtual stones, okay. So then, for present purposes, as the compromise position here. Let's look at the digest and think about where we move what is currently footnote 3. So we could, yeah, great.
It'd be after the first sentence, I think, is where it would be.
Yeah.
Any disagreement with that? All right.
Yeah.
No.
Let's move it there for now.
Yeah.
And if you want, Angela, I mean, whatever's easiest for you, if you want to move it now or later, it doesn't
Yeah, I'm
matter.
gonna move it later, so I don't.
All right. So why don't we go back up to the issue section and close this out? So do we have any other suggestions, comments, or concerns about this new language? It starts in the highlighting of the second paragraph. What are the ethical obligations of lawyers with respect to retention and destruction of client files, materials, and property in closed civil and criminal matters?
Point of clarification. So the third sentence or the last sentence that's in quotation marks is going to replace the first two sentences under issues.
It's gonna be the whole thing. It's gonna become the issue.
That one sentence.
Yes.
Okay,
Just-
just making
yeah, where
sure.
it says
Because
just,
it kind of seems redundant to keep the first two then. Okay, cool.
So unless there are any objections or further comments, I would propose that we in the issue section, delete everything except for this new language, and that would become the issue phrasing that we would then send out for public comment. Any further comments, questions, concerns, objections? All right,
Delete
why
it.
don't we do it?
Delete.
And then if you wouldn't mind getting rid of the Justin likes it on something.
Yeah, we can clean that up later. Don't worry about that.
Okay.
Justin said we have to do this.
Okay, so now that we've cleaned up that footnote, we've updated the issue section. Let me open it up for any further thoughts about the body of the opinion. If there's anything else that we want to discuss, because I think we're probably going to be inclined to move this towards further around to public comment today. So if there's any further cleanup that people want to discuss, why don't we do that now?
So I have a little bit of a concern about confusion resulting from footnote 7.
Footnote 7.
Because I think we are accurately describing,
The one that says attorney work product?
yes, the uncommunicated work product. And I think it's probably accurately describing the open question as to an ethical obligation but I think the way it's worded, when it talks about, on here, the squib on Rose v. State Bar, whether an attorney has a duty to surrender uncommunicated work product to a client for client's use in a malpractice action appears to be an open question. So that's a disciplinary case where there was a file request made. But I think it's a little confusing in terms of like the CCP in a litigation certainly opens this up. And I would want to clarify that we're talking about it being an open question as to your file return obligations, because I guarantee this is going to be cited
Yeah.
by people saying, I don't have to produce this in discovery. Look, it's an open question.
When I read that, I
Well,
was
the
like,
flip side
oh,
too.
Yeah,
The
yeah,
flip side too is the,
Yeah.
on the side, they're gonna say you need to cough it out or
right.
cough it up, and the defense side is,
Right, and we have that CCP 2018, which really talks about work product in litigation, and in a litigated context, you know, it's just different from this analysis. And I'm not exactly sure the language to clarify. I was thinking the first sentence could say, you know, whether a lawyer has or is ethically obligated, like as opposed to inactive litigation, you know, legally obligated. It's different, you know.
yeah,
I'm not
I don't
really
think
quite
we
sure.
need to go into litigation for
Yeah.
purposes of this opinion.
Just to say that that's a different issue. It's
Yeah,
something
that's,
we're
we're not addressing that.
yeah, I think that's a good, that's probably the best. Yeah, I agree. I get the same.
So just putting the word in ethically obligated, you think would that
Yes.
feel comfortable?
Well, and I wonder if we should say in parentheses in the footnote somewhere that this is not addressing discovery obligations in litigation.
But that would be outside the scope of this.
Exactly, something like that.
Yeah, I'm comfortable with drawing that distinction. I don't think
Yeah.
we need to talk about litigation in
Right.
this matter. And this language, well, first of all, let's address your comment first. So Angela, okay, perfect. So we've added the word ethically obligated. Any comments on that, or is everyone good with that?
If we're not going to get into it, why do we even need that then?
To the malpractice, yeah, I mean, I kind of agree with that too. So-
If we're just looking at the ethical obligations here, why get into the malpractice litigation issues at all? Just take all that out. Or we could just say this does not address discovery, issues in litigation between attorney and client and legal malpractice, or whatever, however we want to phrase that.
Well, I think this, just backing up, I think this footnote stems from this last bullet point on page 5 of the red line about what product the lawyer has to turn over to a client upon request. And I think part of the raising issue starts there, because right now we're saying that what has to be turned over is attorney work product reasonably necessary to the client's representation. And there's this addition that says that that would include work product, whether or not communicated to the client. And I don't think that that's consistent with the footnote, which is saying that it's an open question.
Right.
So we've got some revisions that I think we need to do to make that statement in the body consistent with the footnote, while also clarifying that, to your point, I think Ken, it was, that we're not getting into malpractice and litigation in general.
Well, why don't we just take out the reference, would it be problematic to take out the reference to Rose v. State Bar? In terms of that, and just not sort of have that question, even as Ken pointed out, like, why are we talking about legal malpractice here and making it
Right.
clear that we're just saying like the obligation, the ethical obligation to really, because we're really, I mean, this whole thing's about your ethical obligation, it's not related to litigation. And it, you know, that duty is dependent on the interpretation of, you know, 1.16 and various provisions of that. And citing to that state bar opinion, and then I guess the other matter where it's just said, you know, I mean, I don't know if we need all those string sites, I mean, you know, I'm not sure that helps, and I don't wanna,
Rose v. State Bar is confusing,
yeah,
unless we really, really explain
So,
it.
yeah, why did the court reference malpractice?
So what happened was the client wanted to sue the lawyer, but hadn't sued the lawyer,
Yeah,
demanded a file.
right,
And the attorney said, the matter's closed, because he screwed up the matter, it's dismissed. And he said, so you don't need the file, so there's really no obligation to give it to you. And so it is true, that site is absolutely accurate from Rose, because it's like, she wanted the file in anticipation of malpractice litigation
right.
to review it and decide whether to file. But without all that context, it seems like in a malpractice litigation, there was this open question. I don't think that's true. And that's not what we're trying to say. We could remove Rose completely and just have that parenthetical that this is focusing solely on ethical obligations and does not, or, you know, any litigation discovery issues are beyond the scope. Something like that.
I would agree with removing the reference to Rose, but I don't think we need a parenthetical. I think we can just openly state, and I think it would work as the last sentence, that that's not what we're addressing.
Great, great.
I also wonder along those lines, and I think you'd be better positioned to answer this, because I know you deal with this a lot, but just whether we should remove the other parenthetical to the other case in front of it. I mean, we have in the matter of Regan, I mean, I think, because it's talking about uncommunicated attorney work product, and we kind of, you know, basically went back into, you know, the body of the opinion, and we talked about work product. We took out the communicated, because distinguishing between communicated and uncommunicated, we didn't really want to get in a conversation about that,
Right.
and that's not, it's the question is whether it's reasonably necessary to the client's representation, which involves an interpretation of Rule 1.16 D and E, right, and not the question of, I wonder if it makes sense to take out both the sites.
I think it does. And one of the things that I did want to point out is this is where we got a lot of public comment last time. And it seemed to be on the substantive question, this like the substantive law question that we're trying to not address. So I think that excising it completely will probably be a better idea.
Okay.
So I think there are 2 points we have to keep in mind. One is what we're saying in the body, and then what we're saying in the footnote. So right now in the body, the revision that we have is not consistent with, I think, our intention. If you look at the last clause in that bullet point on attorney work product, it says that the lawyer has to turn over work product reasonably necessary. And then it says at the end, whether or not communicated to the client. And I don't think that's consistent with what we're saying or the law, frankly. I think what we're saying is there's an open question whether or not a client is entitled to uncommunicated work product. And we're not answering that open question because that's outside the scope of what we do here at CoPrac. So number one, I think we need to, my proposal for the body here would be to put a period at the end of generated in the course of the representation, period. I don't think we should be weighing in to say whether or not communicated to the client. I think the whole purpose of the footnote is to say, we're not weighing in on this legal question which hasn't been decided.
Yeah.
We
So
had
those-
discussed that before, though. I
Reasonably
mean,
necessary to the representation is direct language from 1.16 E1, and that's the standard to produce the file. It's got to be reasonably necessary for the representation. So that other ethics opinion that it's citing to is saying, regardless of whether you communicated it or not, if it's reasonably necessary to the representation, under the ethics rules, you have to produce it. So that bullet point is an accurate statement of that. Now, the question really is a factual question about what's reasonably necessary to representation. And
Right.
obviously, there's going to be a lot of uncommunicated work product that is not quote unquote reasonably necessary to the representation. But that statement, I believe, is accurate based on 1.16 E1.
Well, then what is the open question? Whether you have to communicate, whether you have to produce uncommunicated work product that is not reasonably necessary?
Yeah.
Okay, so then we have to slice this more finely.
I mean, yeah, I mean, that's the San Diego Bar Association opinion is really good because although this was like after the, because there was changes in the rule which made that reasonably necessary standard like wasn't in the rules before and then it was, and so that, but that's in 1997. I think that's the opinion, because I remember I looked into this a lot when I did the presentation for the mid-year, for the symposium. And like going back and being like, okay, there was some earlier opinions that are based on older, language of the rules, and the rules were revised, and there was some confusion that was cleared up largely. And I really felt like that San Diego opinion really distilled the updates to, which we carried over into the new rules in 2018, like that phraseology, but that reasonably necessary, they cleared up some of this confusion, I think,
Right.
prior to that time about, what was a triggering event to produce files and what needed to be produced. And so, and I, this is also sort of a holdover from some of the research that was done, and I think when Amber was researching it, so it's like some of these cases I don't know as well, right? And I don't really know that in the matter of Regan that well, but I do feel like the standard, that articulation of the standard in that bullet point is accurate based on 1.16E1, which says you have to produce all materials and property that are reasonably necessary to the representation, and whether it's work product or whatever it is,
Right.
like that's the standard. So,
So then the footnote has to say, has to describe what the open question is.
right, and what is the open question?
The open question is whether you have to produce uncommunicated work product that is not reasonably necessary to the furtherance of the representation. And the reason that squares with Rose, I think it is because that case was over and the client was just doing like the free pre-litigation discovery. So, and the attorney said, none of it's necessary to the representation.
Right.
He was actually right.
Yeah.
But they found him, they disciplined him, because he just didn't produce a scrap of paper. He's like, your case is over, you don't need anything.
But then, so not differentiating between work product and the rest.
They said that's an open question, but here he produced nothing and he had no justification. He's
I
out
don't,
of this.
if it's not reasonably necessary, I don't think you have I mean, is it really an open question?
Well, it's your property, right?
Your work product is your property, and if it's
Well-
not reasonably necessary, you shouldn't be required to turn it over.
So Rose cited another case, which I haven't looked up yet, because my technology has all failed, but let me see. I'll report back in a moment if I can read small enough.
I mean, let's be clear that the rule itself goes on to say if the client requests it, you have to produce the following things and other items reasonably necessary representation. So it's not just like, the standard is like, he can say it's not reasonably necessary, so I'm not gonna produce anything. Of course, there always is the duty to produce all the things listed in the rule, right? Which are very broad. Communications and, correspondence and pleadings, but the question of work product, I think, kind of gets into that second part of that, which is like, because work product is not expressly referenced in the rule,
Right.
that is gonna be something that you're gonna say, is that under the clause reasonably necessary to the
open
representation?
question. Yeah.
Right, and so then the open question becomes, but it's not whether it's communicated or not, it's whether it's reasonably necessary.
Yes, yeah.
And so, but some people have made that distinction saying it's not communicated, so it wasn't a communication, and so then the question under the rules, it's not considered under the category of like the correspondence, right? That would have to be produced. It's work product, and then the question is really whether it's work product. It would presumably be uncommunicated work product because you
If it's
communicated it,
it's
it
going.
would be part of the correspondence, and so is it reasonably necessary is really the question.
Yeah.
All right, so solve that problem, no?
Well, I'll tell you that the case that Rose is relying on for saying it's an open question starts out by being one of these active litigation cases.
Right.
Where the beneficiaries of a trust are suing for the privilege between the trust and the,
Oh, gosh.
so it's going to be a nightmare.
Right, it's gonna be a total mess, yeah, really difficult, yeah.
I just think it's dangerous. I don't know. I just think it's dangerous to open a question that, in my mind, is not so. I think that if it's not reasonably necessary, it's your work product. It's a half-baked idea. Should a lawyer really be required to turn over all of their work product?
Well,
Yeah, and I agree, but maybe we just end it, maybe back to your point, Justin, it's like now, maybe we do end it, I think you said this, or somebody, in the course of the representation period. Because if it's communicated, it's a
It's clearly-
communication, it's a correspondence, right? Do we need to clarify that point? I mean,
this is talk about half-baked idea. There is a something in the purple book that says that there's a question about whether there's a communicated work product still is work product. And so, it doesn't and I don't know I can't think of what the, rationale was there. Cause I agree, like, if you're
Yeah.
communicating work product, it should be a finished thought that you're communicating to the client, so that becomes a communication. So I'm just pointing out that I recall something that actually still, characterizes that as work product.
well, maybe if you had a conversation with your client about it based on your own work product, but
Yeah,
I don't know.
I think it may be that if our interpretation is that items generated, including work product, whether communicated or not, fall under the requirement to disclose under your ethical obligations. If we believe that as it's written, this bullet point is correct, and that leaves open the open question, which is really a legal question for litigants to figure out through the court processes as to what are the property rights regarding uncommunicated work product that is not reasonably necessary in the course of the representation. I think that distinction is appropriately drawn by the footnote based on the addition of that caveat that we're not digging into that issue. The only thing that we're stating, and we're stating it forcefully, is that it is an ethical obligation to provide items generated in the course of representation that are reasonably necessary, whether communicated or not. If that's where we're coming down as an ethical obligation, I think we should say so. That only leaves open that small question, and that small question, we're not weighing in whether it should be one way or the other.
I think that's
Can
right.
I weigh in?
Yes,
Okay, two thoughts. Based on some testimony I gave in a deposition a week or so ago, I think it's important that we really do articulate what we're not covering so that they can't be mischaracterized by an opposing expert, as one of our opinions, I think, was in that case. But more than that, don't we have an ethical opinion somewhere in our great body of good work that that if you make a mistake, if you commit malpractice, that's something that you do have to communicate to a client? And if so, maybe the malpractice is that you previously didn't communicate important work product to a client. So, and third of all, I've always felt that the client has been charged and paid for it. It really should belong to the client, which is why I have sort of always come down on the side of concluding that if the client had paid for it and it's relevant to the representation, even if the representation includes what you do about fixing the mistake in a subsequent litigation, it should be communicated whether or not it had been previously communicated.
I completely agree with you, Joel, in the context of litigation.
And that's been kind of the rule.
Right, I'm not sure. I'm just not confident enough. I mean, I normatively agree with that. I'm just not sure that's all the case ethically in terms of ethical obligations. I'm just not
Well,
sure.
I mean, I don't know, Joel, we do have an opinion that says that, but I would be inclined to the first point that you made, which is just about the duty to communicate a mistake, but I don't want to go too far afield in this footnote. I feel like we really want to rein it in, because this is already a longish opinion, and just make it clear we're talking about ethical obligations, right? I mean, I feel like the footnote and reading it the entirety together, like the first part of it, I think is exactly what we want to say. It's just the question is like, because we say whether a lawyer is obligated to release attorney work product not previously communicated to the client remains, we could say, remains an open question. And you could say ethically obligated, Brandon, I liked that clarification, and involves a fact-specific inquiry that depends on whether it's reasonably necessary or might result in, the reasonably foreseeable prejudice to the client if withheld, so those are directly from 1.16. And then maybe we just don't cite to those two cases, we just cite to the other ethics opinions, I don't know. I mean, I know it's more powerful to cite to discipline cases or other cases than just an ethics opinion.
Well, I mean, citing to the cases, I think, or at least one of them, you know, cite both of them if we want to shorten this. I think rounds out the debate, you know, and why we're not delving into this, because I think as this conversation is just illustrated, there's this tension between how one might plainly read a rule
Yeah,
about what you have to turn over, and then what these cases are saying, and then normative feelings, put it all together, and there's this confusion that I don't think we want to step into. And so I think it's helpful from a reader's perspective for us to give them both the ethics opinions and at least one case, so that they can understand, you know, that there is this tension, there is this disagreement, and we're not wading into it. All we want to point out is that if attorney work product is reasonably necessary, yeah, you know, with the caveat that there's this one disagreement about uncommunicated work product, you need to turn it over.
because obviously there's always going to be a debate about whether it's reasonably necessary, and people are going to have a different, like
Right.
that's obviously a factual argument that it's,
Well, I if that was Justin, I think I completely agree, because what happens is somewhere out there, there's an attorney who's going to pick up this opinion and it's going to say, well, Coprac said it was okay, or Coprac said this. And it's important to, even if it takes a little extra space, to clearly set out, there is another controversy, here's what it is, and we're not weighing in on it, but maybe you should.
Who should weigh in on it? Are we supposed to be weighing in on these things?
No, this is cases have said this is an undecided question. I do not think that is what we want
I
to
mean,
do.
I guess the question is, do we need a sentence like you originally raised, Brendan? I think the question sort of is like, do we need a sentence that says we're just talking about ethical obligations, we're not talking about duties in a legal malpractice context to produce discovery, obviously.
I think that would do it, because all I can tell you is it's getting more complicated the more I'm trying to read that case on my phone, because it's from 1985, and it says the attorney's work product protections are absolute.
Which case?
Sorry, it's the one cited in Rose.
Oh, okay, good. No,
So
go
I'm
ahead,
like
sorry.
3D, and I'm not sure whether that's before CCP 2018 was.
It's that 2000 or that 1989 is before, it's the old formulation of an older rule, and then there were some revisions.
Like, we can't touch,
Yeah.
we just have to cut this off in an accurate, clear way as to what we're not delving into.
Yeah.
Because this isn't.
Okay, so we've said we'll take out Rose, I think we all agree that. The
Yeah.
second question is, do we take out the other case or not? And then do we add a sentence that clarifies, we're talking about a lawyer's ethical obligations with respect to releasing client files and not about,
Discovery
litigation.
obligations and litigation.
Yeah.
I really think that sentence will stop all the mischief that I think Joel and I are concerned about,
okay.
the confusion or misuse of it. And it makes it clear what we're not delving into, so.
Well, why don't do you want to propose a sentence for that?
I like what you just said, and I can't remember it. This opinion concerns ethical obligations and does not.
I mean, I think we could do it as a last sentence, because we
Yeah,
say,
in
our
the
last
footnote.
sentence is for the purposes of facts presented here, it is assumed such and such. And then we can say.
We can say,
Sorry.
this opinion concerns an attorney's ethical obligations only and does not address discovery obligations and litigation. And then we're just not touching 2018.
Ethical. Yeah,
Or
ethical.
pre-litigate, yeah, right.
Yeah.
Let me push back though, I wonder if we need to go further here. Because this question of whether uncommunicated work product has to be turned over to a client short of litigation, just in the ordinary course of a client file demand, I think it's still a disputed question, whether and when that uncommunicated work product might trigger the reasonable and necessary analysis and all of that. I don't think we want to touch that. So maybe we want to be broader in our footnote to say that basically acknowledge that there is this dispute or undecided issues surrounding uncommunicated work product, and that we're not trying to answer that question. We're just pointing out that lawyers, have this obligation to turn over attorney work product. Caveat, there's this dispute about uncommunicated work product. We're not touching it.
Well, I think to the counter of that, I don't necessarily agree that, I think it's pretty clear that there is a duty if it's reasonably necessary to the representation or might result in reasonably foreseeable prejudice. And a lot of the comments we got back when we were broader about it, which we tried to be more specific and cite to that particular language, was that we can't just say that we can't leave it an open question saying, oh, we don't know whether or not they have a duty, because that's not accurate. And people were upset that we suggested that the lawyer could kind of couldn't produce uncommunicated work product if they didn't want to, or that there was no definitive guidance on that point, and there is in the rules. So I don't want to suggest that because that's where we started with this. And the public comment, there was a lot of public comment saying that's not accurate to say that it's unresolved, because it is resolved if it's reasonably necessary and if it complies.
Well, so maybe we should reformulate if that's the case.
But we may not all agree.
Then we're burying the lead.
I gotta say, I hear what you're saying, and if that's right, that's right. But what I'm stuck on maybe it's a wording thing more than what the actual law is.
Yeah.
But how we say in Rematter Regan, how we paraphrase it, it says client file absent uncommunicated attorney work product must be surrendered. So that suggests that pre-litigation, you may not have an obligation as a lawyer to turn over uncommunicated work product. Doesn't tell me anything about whether reasonably necessary.
I know, well, that's why I don't like that
confusing.
string cite. So the part we added, and I think we even debated this as a committee about whether to leave those string cites in, and those were string cites from the original. Again, I don't think anyone here was drafted the string cite, and I'm not as, I think I looked at those opinions at some point way back when, but we wanted to highlight the San Diego Bar Association opinion because it really did a good job, I thought, of saying here's the two factors about under the rule about whether it's reasonably necessary or result in prejudice, is how you determine whether you have an ethical obligation to return something to a client or to release certain,
I've always understood that to be the standard.
Yeah.
You don't have an obligation to turn over uncommunicated work product unless it's reasonably necessary or the failure to do so is prejudicial.
Yeah. That's also a formulation of that, yeah.
Yeah.
So do we believe that statement is controversial at all, or are we all on board with it?
That's the question. That's my question too.
I think that's controversial, but
Then it shouldn't be in a footnote, we should be,
Well, that's what the bullet point says, right?
right.
okay.
But the bullet point, if we get back to the bullet point, and this is what generated my comment way back when that's mentioned in the footnote. We're talking about research notes regarding witnesses. The strategy part's a little bit, if that's not on paper or anywhere, or similar items generated in the course of representation. Why would those not be part of the client file? If you as the lawyer interview a witness and prepare a memo regarding that, well, what grounds do you have to withhold that from the client when you did it during the course of the representation? It's part of the file.
And that was what a lot of the public comments were saying. I think that we're onto something with regard to what we're doing here. So if we remove the string citation, because really we're not trying to get into a property rights discussion, right? Who has the right to this information?
But it does go back to that analysis is why work product is owned by the lawyer. What is work product and the rationale behind that difference. And, respectfully, I think Ken's trying to eradicate that difference, and.
No, I don't.
I didn't mean to be,
I haven't looked at the Reagan case in a long time. I don't recall what they were talking about. And that's why I do have a little, when it talks about strategy and tactics. If you during the course of a representation, in your mind, thought, this is the best approach to handle the case. This is the strategy that I would use. You don't communicate that to the client. It's not on paper. It's not anywhere in the file. Arguably, that's your work product, and you don't have to generate a piece of paper or provide that uncommunicated thought process to the client. But I mean, the other stuff we're talking about, research notes, notes regarding witnesses, any of that stuff you're doing during the course on behalf of the client. And I would get back to, if you're doing it, and it's, it implicit is that it's reasonably necessary to the representation.
Well, then
And
that's.
it's something that should go to the client.
But
Oh, is there any case where an attorney would bill a client, require the client to pay for some activity that then would be found not to be something that was generated in the course of the representation?
But that's not the
That's
test.
the test.
Yeah,
not the
and there's
test.
a lot of contingency work and other work that is not billed to the client, and you're not gonna say, oh, they can't have it because I didn't bill them for it. I mean, that can't be the test.
Yeah.
So I gotta say,
Well, you would be billing
we
for
can
it
go
when the
back and forth on
contingency
this
occurs.
all day long, and it's not our fault. And I gotta tell you, it's not our fault. I just popped open this matter of Regan case, okay? 2005, right? So here's what it says. We basically say the holding or the statement at issue in our footnote, which we're all confused about. All it says is, quote, a client's file, absent uncommunicated work product, is the property of the client and must be surrendered to the client promptly upon request, once the representation has terminated. So it's talking about a client file request, nothing to do with litigation, and it's making this distinction about uncommunicated work product without any analysis whatsoever about reasonable necessity, right? And so we're struggling with that because a lot of us feel like, well, if it's reasonably necessary, even if uncommunicated, you have to turn it over. But this case and how it has framed the rule has created a lot of, I think, uncertainty or confusion. And then you couple that with ethics opinions who maybe, which have gone further and tried to explain that there is a reasonable necessity component to uncommunicated work product. And you end up, I think, with a tension between sort of this unclear but firm rule without any context in this case that gets cited time and time again. And these ethics opinions that are trying to add nuance to it. And who's right and who's wrong? A, I don't think we can weigh in on that. And B, I'm not entirely sure what we do with that when you have a legal opinion and then ethics opinions kind of saying different things about the same issue. And so with that tension, again, I think we're trying to be nimble about making sure lawyers know that they can't just withhold things that their clients are entitled to without actually reaching our own conclusion about where the line is drawn. And so I think that's where we're having a problem here that we can't resolve because there is this tension that we didn't create that has existed for 25 years. So,
But it doesn't say that all that uncommunicated work product wouldn't necessarily have to be turned over under this analysis. It's just saying 100% for sure the other stuff that has to be turned over.
well, I
right?
hear what you're saying with it, but the other, there's a bar of lawyers who would want to disagree with you and say, no, this is firm, this is clear, there's nothing beyond matter of Regan that says that I have to look at reasonable necessity, this is how the rule is interpreted, blah, 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 whether they're right or wrong. I'm not saying that. All I'm saying is that I don't think we want to decide who's right and who's wrong, even if we think one side or the other has a better argument.
Well, so then the question is, as it's formulated, what we have now with the footnote, is that accurate in light of what you just said, or do you think there needs to be further clarification?
Let's take a look.
Is there a way to take out the red line for a second?
I can see the whole footnote at once.
Under view, click, well, there should be one where it says, a review, under review, click,
There's no number.
Why?
I don't see it.
And not work product.
No markup.
Unnecessary.
What does it say? What does it say?
Contingent to no market.
Other items reasonably necessary to the client's.
Oh,
What does that mean?
yeah.
It was like an effort to be vague in case someone didn't think of something, right? But then we're like, well, what are the other, like, you know,
Yeah, well,
sometimes,
more product is the other thing.
I know.
I think we need to get Rose out of there or rewrite the squib or something, because the mention of the word malpractice in there, so.
We're gonna take Rose out. I
Okay,
think
we're
we
good.
agreed with
Yeah,
that,
Yeah,
right?
the
Okay,
reference to
okay.
Yeah, I think the
malpractice.
question is whether we keep in the matter
The
of
rest.
Regan in there and then whether we make any other changes. So the one that's highlighted in green is one that you suggested, and then the green below is the other suggestions. But
One of the issues with the last sentence as it's phrased, though, is that the opinion specifically does get into 1054, which is about discovery. So it's not that the sentiment isn't correct, but we might want to change how we phrase the last part. Does not address discovery obligations, but maybe does not seek to settle any open legal questions about who's entitled to what.
Could we say malpractice litigation?
In legal malpractice.
Legal
yeah.
something like
That's a
that?
great point, Hunter.
Yeah, because then we have avoided conflicting with what you're talking about.
Is it obligations in malpractice?
In.
Of course, there may be discovery obligations in other litigation, but.
So,
Right?
Well,
can you scroll to the top of the footnote we're talking about? I mean, I gotta play the devil's advocate approach here and say 116E1 doesn't say that. It doesn't say the attorney work product is part of the client file. The information is reasonable, and that's reasonably necessary. It doesn't,
That's what that San Diego Bar Association opinion says.
well, but that's, I mean,
so the San Diego opinion says, interprets other items to mean one product.
So let's, if I may,
As does the San Francisco opinions and stuff too, you know.
Yeah, I mean,
Justin, you said something that I thought was really interesting, which is that, we shouldn't wade into we can't resolve this unresolved thing. Is there a role for COPRAC to say, we believe X?
that's my question.
Yeah, because maybe we are the people to do it if we feel that way.
Because we're not providing much guidance. I mean,
I'm open to what Mimi, Erica, what you might think. It does seem to me though that it would be addressing a legal question if we decide what constitutes the client file as opposed to talking about ethical obligations surrounding client files. I think to me, it's a step too far, particularly since the ethics opinions out there and the cases don't seem to match up.
Yeah.
So for us to weigh in there, and potentially disagree with granted a somewhat vague case that we've been talking about, gives me some pause, and I think we would get a lot more public comment on this if we were to
But
try to weigh in.
the most public comment we got was the fact that we didn't address this part of the rule, and specifically, I mean, the ethical question presented in the San Diego Bar Association opinion, I understand that it's not binding, but I'm saying from an analysis perspective, I thought it was very well thought out,
Well,
and from a.
You're persuaded by it.
I'm persuaded by it.
And
And
could
the
we,
question was whether an attorney may ethically withhold from the client the attorney's uncommunicated work product relating to the client's representation. And they do this analysis, they talk about how under some of the prior opinions and rulings that the formulation of the rule was different, and they go on to discuss, I mean, I think it's, and they cite, I mean, I think it's a very well thought out and analyzed. I was persuaded by the opinion. I agree with the opinion.
can we adopt it? You know what I mean? Like, is that?
can we say it is the opinion of this committee that the ethical obligations require X?
Yeah, in line with what the San Diego.
And I understand that is putting us out over, we're not on, terra firma the whole way, but is that part of our role to say this is, because it's not a legal conclusion, it's just an ethical.
Right, it's an interpretation of ethics rules, which is what we do.
Yeah.
Right? Again, to the extent that they don't create new law or something like that, but I don't
But
think it's like going out on a limb to say it.
Yeah, Brandon, I think that's exactly what we're doing by putting that footnote there, which says the things that are reasonably necessary to representation, and then backing it up with this footnote. We are adopting the position that that's the proper analysis.
Because I agree with the San Diego opinion as well, but
Yeah.
should we vote on whether we want to have sort of a bold statement like that, or is that appropriate for a vote? I just don't know the
Well,
metes and bounds of our role.
The other thing we could do is like over the lunch, maybe people could read the opinion and honestly, it takes you 3 minutes to read it. It's not super long. And maybe then we could reconvene, like revisit
Sure,
this after lunch and say what people are comfortable with related to, you know, I don't want to go, I am uncomfortable trying to reconcile sort of a legal standard with the ethics rules for sure. That's not something that we're, you know, is really the main focus of what we do. But in terms of saying that, I mean, I feel like it's a pretty clear reading of the rule to say like other items reasonably necessary is broad and certainly should include, it doesn't say except uncommunicated work product, and there's no reference in the rules to like excluding uncommunicated work product. And so, you know, I feel like that's a pretty, I agree with the reasoning in of the San Diego Bar Association opinion is what I would say.
I know, I think it strikes a balance between the client's interest and the lawyer's interest in the work product. I mean, that's the thing. If the
Yeah.
lawyer, you know, you have to preserve that right to your ownership of your work product, which is
Yeah.
fundamental, you know.
Is this a important issue that we are kind of like burying inside of a file retention
That's a
opinion?
good question.
Well,
If
I
we
mean,
are gonna make this, like, we endorse this is our view and it's important.
but I think the problem is like we have, I mean, if we did agree with the San Diego Bar Association opinion, then we're gonna be writing an opinion that's the same as what they said, so why do we need to do that? Instead, incorporating and saying we agree with the holding here. And we could be stronger about that if we agreed with the holding there, and that was like, we you know, agree with the reasoning of this analysis, and we think that that's an accurate application of the rules to the duties to release, you know, client materials and property.
So let's do this. Over the lunch, if folks can read the San Diego and San Francisco opinions that are cited in footnote 7, and if they want to read the Regan or anything else cited here that they think would be helpful for this discussion. Let's pick up the discussion about this footnote after lunch, once people have had a chance to read those opinions. I'm seeing we're going to have time. And then to the extent there are any other comments on this opinion, we can finish up the discussion. And then hopefully be in a position to move this out for another round of public comment. Does that work?
Yeah.
I'll go ahead and circulate the opinions and those two ethics opinions in that case to you guys by email, so you don't have to go searching for it.
Thank you.
That's awesome.
Thank you. So next on tap, we have
I had one more question on this opinion, though.
about this footnote or something else, because we're gonna come back to it.
No, it's not about the footnote. It's in the,
We'll come back to it after lunch. We'll cover the next
okay.
piece. Yeah, thanks.
Thank you. All right.
So 20-0001. Sarah's not here, so I'll take us through this. The idea is just to have a short discussion to get any feedback from the committee based on where the drafting is. Just to highlight some of the changes that have been made. The main one is really structural. This is a very dense opinion, and so what we talked about before is moving the analysis directly following each of the scenarios that are presented, as opposed to having the 4 scenarios, and then you have to somehow try to remember them, and then have 4 fact analysis. That was, I think, difficult for the reader. So now it's been restructured to have scenario and then analysis, scenario and then analysis. So I'd be interested in any feedback from the committee if you think this is the right approach for this opinion. I think it's from a read of this, there's some rough edges we'll have to smooth out from that reorganization, where we might be talking about something that says, you know, and as we discussed above, well, it's no longer above. So I think there's some massaging of language that will need to happen based on this restructure. I think related to that, I wonder if the issue section should be simplified, similar to what we just did in 19-0004, where we have a sort of broad 1-sentence issue. Personally, for me, the 3 issues as presently framed, while interesting and explanatory, it already is forcing the reader to think real hard about these scenarios in a way that I think, starting to work through the facts before you work that hard mentally, it might be easier to simplify the issue. So that was my thought there. So with that, I would open it up to your thoughts about the new structure and then whether we should simplify the issue section. And then the goal will be to sort of report our thoughts to Sarah and then have another iteration of the opinion that's hopefully a little closer to final.
I have some comments if I'm ready to hear them. I like the changes that were made. I will point out and I'm looking on the clean version, so that in that section where it was moved around and starting in section 67 or line 67 on the clean version, so I'm gonna have to say, I have to figure out what.
In the discussion section or before the discussion?
In the discussion section. It starts with like the paragraph that says here. So yeah, I'm sorry, it was hard for me to track with the red line, so I
Yeah.
looking at the clean
Yeah, I see
section
where
and
you're
now
going. I see where you're
I'm,
going.
so
It's line
obviously.
100 of the red line.
Okay, thanks, Justin. So I feel like that section where it's like here, the lawyer expressly disclaim, obviously that needs to be revised because it's talking about one of the hypotheticals, but I felt like that whole section about, and I felt like this about American Airlines, where I kind of just feel like, I don't feel like it certainly doesn't fit in here. It takes me completely away because it's like this specific issue, I think, that we haven't even really talked about yet. And I don't know if I feel like it even belongs in the opinion, I'm gonna be honest. And I know that that was one of the center points of the opinion, but now that you've moved it around and I go through the other analysis with these typos separately, I'm like, oh, I'm tracking this analysis and I think it's good and it makes sense to me. And then I'm like, where does this fit in? And if it fits in with one of the hypos and maybe in a footnote. Because it's just, I don't know, I feel like we're spending too much time on it where it's very distinguishable from what we're talking about.
I agree with you. I completely agree. This, the 30B6 role, having fiduciary duties, is pretty distinct to my mind from expert witness testimony. And
Yeah.
so, and it just doesn't flow because we're really focusing on expert witness and we take a big detour into this thing that doesn't seem as applicable to our scenario. So maybe it can be condensed, maybe it can be moved or addressed in one of the explanations of the scenarios or something.
Yeah.
I couldn't agree with you more. I think restructuring to have the scenarios followed by the analyses really crystallized in my mind that this American Airlines discussion is a bit of a side track and would be better left to either a footnote or shorter discussion because it's this complicated discussion that isn't, I think, necessary for the purpose of the opinion as it's currently written. And so I do think we need to think critically about whether we keep it, omit it, narrow it, move it, etc.
Okay, so that was one, I had 3 comments and then the second one relates to, and again, I apologize, it's right before the end of, right before the beginning of scenario 4. And so I don't know what the red line
In
comment.
scenario 3,
Yeah, at the end of scenario 3.
okay.
And it was a question that was posed in that related to whether we should talk about discussing disqualification risk in scenarios 1 and 2. And my opinion is that yes, we should. Like that discussion should be as part of, because it relates to scenario 1 the same way. We can have a mini discussion or a sentence or however we decide to present it. And then we can just reference it in the other scenarios, and like that would be a consideration as well to the other scenarios, like that it should come first. And I think it's an important distinction to make because it relates to, I mean, there's a great discussion. I mean, I think I like the way it's presented and I do think it should be incorporated earlier. And then my last comment is just about, and I know Sarah struggled with this and we've struggled with this in general, is like, what is this distinction between scenario 3 and 4? And I don't understand how you would not be adverse to a company if the expert's testifying as in a way that's in opposition to a company.
So I can't figure out, scenario 4 has exposed the limitations of my brain. And,
or mine too.
well, and there's this part where it says represents in a separate but unrelated matter, that's in the green red line, but when we go down to the text, it says representation with a party in the same matter, something's wrong.
Right.
It's not,
In one case, they say that they're not adverse, and the other they are, but I'm like, how are you testifying in opposition to your former or current or whatever, but in a way that's not adverse to them? Why wouldn't it, wouldn't it always be adverse to them?
I wonder if the opinion is stronger with 3 scenarios.
Yes.
It certainly would be less difficult to follow, because I tell you, scenario 4 versus scenario 3, every once in a while when I read this thing, after about 10 minutes of thinking as hard as I possibly can and getting away from my screaming children, I can understand the distinction.
Okay.
Like, oh, it makes sense, scenario 4. But is that really what we want our readers to have to do? I don't think so.
No.
And while there might be some value to scenario 4, I think we're reaching the consensus that it might be outweighed by the difficulty of the reader to try to internalize this difference between 3 and 4. Does it really add enough value to include? I'm starting to think maybe not, and that it might be worth cutting to, again, help simplify this read.
That would probably be my vote.
Yeah.
Just-
For that very reason, even if there is a distinction that someone can articulate, I know we've struggled with it, but if it requires a lot of deep thinking in a way that's not gonna add a lot of value because that, sort of nuance isn't common, or we can address the nuance when we're discussing scenario 3 in a sentence, then I just think that's a better approach, because I think if we're struggling with that distinction, then obviously we're not gonna be the only ones.
For sure.
So those are my comments about it, but I definitely think it's moving in the right direction. I mean, it's definitely, I think it could be retweaked and be like pretty good to go. I mean, I think there's not, but I think it's in the right direction in my opinion.
I think it's better with this, I like this rework, and I think it'll be more valuable to the reader. I have a question or a concern about line 269 of the red line. And there we talk about how we don't impute a conflict based on a personal interest. But we've got a sentence there that I have a problem with that I can't exactly put my finger on, but accordingly, if the law firm can provide effective representation of defendant without experts' participation and without compromising the fulfillment of experts' contractual obligations to the plaintiff, experts' conflict should not be imputed to the law firm. I think the should not be imputed doesn't belong there. I think it means that the law firm can proceed with the representation and doesn't have a conflict. But I don't think that's the test of imputation. I think we've already talked about the test for imputation. We're kind of distorting it. Does that make sense?
You're saying that sentence doesn't need to be there because it's too confusing.
Or,
I mean, that part of the sentence.
yeah, experts' conflict should not be imputed to the law firm.
Well, it goes
I'm
to
not
what we
sure.
talked about in the last opinion, which
Yeah.
is like making legal conclusions.
Yeah.
Right, that's kind of what it sounds like. Like, we're deciding there's not gonna be imputation here. I think we can reframe this in a way that's more about ethical obligations than drawing a legal conclusion about when imputation will or will not.
Well, and I think before line 269, we correctly talk about the circumstances under which there is not imputation. And so I think it's correct to say imputation does not apply here, but I think the 269 should be backwards, because the conflict is not imputed to the law firm, as long as the law firm can do it competently and it doesn't, in conflict with contractual relations, the law firm can proceed. I think I don't know, that sentence bothered me.
Yeah.
Not to complicate things, but I had a question about the sentence before that, where it says the conflict created by the expert's contractual obligations of the retaining party are personal to the expert and no other lawyers at the firm. I've had several matters. I just had one where I've retained an attorney as an expert in a malpractice case or a fee dispute. And their fee agreement is I'm hiring that attorney who's a member of that firm, and the payments my client's making are to that expert's firm, not the expert personally. I've seen that in a number of circumstances. I don't know that we can say it's personal to the expert, because oftentimes it's the firm where the expert works and is doing this as part of their employment at the firm where the money goes.
It's true.
And I think that does present an issue that could be imputed to the firm, because they're getting money
Yeah, I mean, I agree with you, Ken. I think, and maybe there needs to be like a comment there. I mean, I don't think we were saying it's personal the expert and no other lawyers. It's saying personally expert, and then the second part of that was no other lawyers at the firm assisted expert with it. So I think there was a sense that, I mean, I agree with you that it's not as clear as like, hey, I'm best friends with the judge in the case, and that's a personal conflict, and it doesn't really, I can just be, but there's always, with the personal conflicts, there's always gonna be a sense if you're a member of a firm, you have a personal conflict, the question is always like, how does that impact other members of the firm, right? Like that personal conflict, which is a similar situation here. But
I don't know, I'd be distressed and, if the law firm who's defending the other or representing the other side is getting money from my client, I mean, that would, to me, that's conflict.
And
So we have to think about-
isn't one of the requirements of a successful ethical screen that you don't share the money? And I agree with you. I've seen countless expert retentions that retain the firm. And I've also seen a number of firms that they base their money split at the end of the year, or however they do it, on receipts from your expert work as well. So
Yeah.
I think that you make a good point.
Thank you.
Yeah, I think we need to.
It happens occasionally, but rarely.
No, it's a fair point. It's a good observation. And it's kind of how the world works with law firms, that that the attorneys, whatever they're paid for, I mean, it's just like with jams or ADR services, whatever is paid is going to the company, the entity, whatever it is, not the individual. How that factors into whether there's a conflict, whether the screen is adequate, I think we need to grapple with that a little bit and see if that informs our analysis. So it's a good observation.
yeah,
What else? What about the issue section? My concern there again was the reader's already having to think really, really hard about the fact patterns based on these 3 questions. And while they cleanly break out what we're going to talk about, I'm also worried we're going to lose readers. They're going to be like, wait a minute, this sounds way too complicated. Whereas if we had a simplified issue that was about ethics and expert witness testimony, maybe that draws the reader in a little bit more than these 3 questions, which are kind of like, trying to do Scrabble. So I'm wondering what people think about trying to do like a simplified issue similar to what we did on the file retention. 1 sentence talking about how this opinion is going to address ethical obligations related to testifying as an expert witness.
I'm in favor of
I
that.
think that's a good idea.
All right. Section, simplify.
I mean, I think some of the struggles with this opinion have been, it's kind of evolved so many times over where it sort of started and we, revised it, that it's kind of hard to keep the thread of, but I think it's moving in the right direction. I think that's.
All right, yeah, I mean, look, there's some cleanup that we can talk to Sarah about along the lines of what we've discussed with the structural changes. But other than that, these are some good high-level comments and specific comments to move this along. Any other questions or comments before we move to what's next on our agenda?
The only other one I had was, where is it? It's on page, I guess page 10, lines 2. It's to talk about the 3rd serial, 291 to 298, where it's talking about testifying, adverse to a current client, but in the unrelated matter. And I guess it's, our conclusion here, it's not the practice, so it's not representation, and seem to be that it's not a conflict, but I keep coming back to, if the person giving that testimony adverse to a current client, if their role as an attorney who's in a firm that's otherwise representing that client comes out, mean, how is that perceived? Does it give more weight to the test of experts? Does it undermine the expert's testimony? I mean, the fact that the expert, is, to me, testifying adverse to a current client, implicit in there is a perception of a conflict in my mind. So I'm not quite sure how to deal with it, but I just want to raise that, and maybe we want to think that one through a little bit more.
Ken, I hate to give you two kudos in the same conversation, but you made me recall the Rayleigh case, which was about 30 years ago, where it was a partner in a law firm was a director at a bank, and that created a sufficient adversity to disqualify the firm, even though they weren't the director at the bank was not representing the bank as a lawyer. And that might be worth looking at.
Yeah, Joel, you mentioned this case before. Would you mind sending us the case site so that we can review it?
I'll try and find that.
That'd be great.
Okay.
So I had a sense similar to what Ken was talking about, just a concern, because the duty of loyalty is a pretty broad, it's, and I'm having trouble tying it to a rule. So I couldn't find a mistake here, just gave me a sense of unease, because clients are entitled to have a lot of faith in the loyalty, the undivided loyalty of their lawyer. And is that limited improperly by having someone at their law firm that they're paying testifying against them, but yeah, I just want to dig a little further, because I couldn't tie it to any error in this analysis. It was sort of a feeling. And I know that was a sort of same feeling that animated Oasis West. But that, it doesn't square with Oasis West.
Yeah. It's like if you're disloyal in a non-lawyer context,
right?
Is that enough to violate the duty?
Well, in Oasis West, it is enough if the non-lawyer context relates to the subject matter of the recommendation. But that's not the case here. Like, I would just never do anything like this, ever, unless you don't ever want clients again. But that's not an ethical breach necessarily.
No, I know, there is an aspect of this too, where you're like, okay, on a practical level, like you would advise people or your own clients about these types of things and be like, that's not a great business practice,
Don't be a jerk,
Right.
but.
Yeah, most firms probably would shut down expert work very quickly.
Right.
Yeah.
So it's not necessarily the most realistic.
Well, but the thing is, it's not completely unrealistic, because I think we've all come across some really aggressive cowboy-ish attorneys over the years.
Yeah.
Who do just kind of wild things that you would never.
Or also in a really large firms with offices like in all
Yes.
different states and internationally, you can see a situation where like, obviously they should have a coordinated conflicts database where they would flag these things, but it wouldn't necessarily be a conflict if someone's representing and then like completely in another context from another office.
Right, someone who's never
It's
met,
asked
they've
to-
never.
Right,
yeah,
and
right.
whether that's a good idea or not, again, the question is, that's
Right.
different than whether that's ethically prohibited and
And that would probably have much less of this challenge to the client's perception of loyalty too.
Yes.
It's not like it's the same, small office or.
Right. Potentially, but yeah.
Potentially.
Right, but I think looking again to make sure we're comfortable that the non-lawyer behavior, even though it doesn't relate to the subject matter of the actual client representation, it's not going to trigger the duty of loyalty. We want to be sure about that.
It's a strong position, and I have a little discomfort with it, which may be not rooted in ethics rules, and I just want to.
Yeah, what makes me think of the appearance of impropriety doesn't mean conflict of interest.
Exactly, right?
It may not get you, you may not have that client ever again, like you said,
Right. But it might not be.
Well, and we could also, if we come to the conclusion that it is ethically permissible, but there's like a discomfort, we could also decide to include a footnote to say like, this, whether it's a good business practices beyond the scope of the, or make something related to best practices and, perception about duty of loyalty, or whether that's gonna interfere with your, client relationship in another way, that's because they would perceive that disloyalty
Right.
is sort of beyond the issue we're addressing, if we find that we're comfortable with what we've concluded here.
Very good. Anything else on this opinion? All right, well, I'll relay.
Yeah, I just shot you the side in chat on Rayleigh.
What?
Oh, it's in the Zoom chat?
Oh,
Maybe
Yeah.
Mimi can circulate it or. Because we're not in Zoom, but thanks, Joel, that's awesome.
terrific. All right, well, next on tap, we have the outline for the ethics opinion for in-house counsel. Cassidy, are you gonna talk to us about where we're at?
Yeah.
Okay, great.
So I think when this started, it was more of a broader, had a broader scope and covering, all kinds of different topics that, an in-house lawyer would be faced in, working in-house. But I think we kind of shifted the focus to make it more, narrow to a conflict situation, really. And the reason for that, at least in my mind, was that this is kind of a sort of a real world scenario that I've seen in my practice, not a whole lot, because I represented in-house lawyers, but it's not, the bulk of my practice. But this is the type of scenario that has come up. And there's not a whole lot of guidance for in-house lawyers. And the one thing that, really has sort of raised, piqued my interest is the fact that, a lot of these in-house lawyers, especially at small companies, startups, are given a real stake in the ownership of the company. And that raises questions about 1.8.1, is it a business transaction adverse to the client or with the client? And then a material interest conflict, the lawyer's personal interests. And I don't, and I'm kind of jumping around because I know we have the former client, the first part of the hypo that talks about, former client, current client conflicts, which I think is important too. And I want to get to does it flow with the opinion? But, the important part to me is the, ownership interest and whether or not, we can craft an opinion that addresses that, because there really isn't a whole lot of guidance out there. So I'm really curious about the committee's comments about the scenarios, and then and just what you think about addressing these particular conflicts, because we could go back to the broader opinion.
I like this.
Okay.
I think these scenarios are fantastic
Oh, thanks.
and very realistic and super interesting, and I don't know the answers. I've actually litigated one of these scenarios, not to conclusion, and nobody knew the answer, which caused the case to settle.
Right, so the question is, can
So-
we provide these answers?
Right.
And so, okay, so I don't know how do you want to go through it methodically, or do you want to have an open discussion about, just the concepts presented by the outline? Because I do want, one of the issues, okay, I guess we can start with, if you're moving from one in-house department to another in-house department, does that raise a 1.9, 1.10 conflict scenario, and how do you deal with that? And the big issue for me, I thought, was, the playbook type conflicts that aren't really conflicts, but I think in the in-house scenario, especially when you're talking about tech and IP, and you're bringing your knowledge about the company's trade secrets and intellectual property to a new company that may be a competitor. How do you deal with that type of conflict, or is it a conflict? So that's the first part of the opinion, or the first part of the outline. And I know, let's see. Well, the first part of the outline is just setting up, the fact that ethics rules apply to in-house counsel. No different, there's really no difference, right? A law firm legal department is, a in-house legal department is a law firm, and that's how it should be treated. And there's nothing that says that there's no carve-outs for in-house lawyers, as far as I know, right? Does anybody know that there's been any exceptions applied to in-house lawyers for any ethics rules?
No, I've heard an argument made that you can't sue an in-house lawyer for malpractice because they're an employee and you have to indemnify them.
Well, but that gets to, right, so that's kind of and when you get down further in the outline, is the salary paid to an in-house lawyer considered to be fees? I mean, or are they wages?
It's nuts.
Yeah,
How unclear is
But
it?
I think these ethical obligations, to your first point, I think it's pretty clear that these duties of like a lot of the duties that are imposed on lawyers apply to in-house counsel. That's the purpose of the preamble. I think that, I mean, to that first question that you raised with that ABA opinion, which we talked about, like that 99, that's directly on point with this, and obviously the ABA agrees. I mean, obviously there's conflict duties that need to be navigated with respect to in-house lawyers, and a lot of, I think that question is something we can't address.
right. But that's the only kind of
But the
exception.
idea that
Yeah.
is there an exception that
Right.
treats them differently?
And it's pretty clear there just isn't, especially, and
Yeah.
and the conflicts rules apply across the board. It's
Yeah.
just, there's scenarios that arise that there's not a whole lot of guidance then, implying the rules that are written for everybody, applying them in this context. And so that's, that's the focus of this opinion. So that's the first part, and then the part B is about the successive representation. And so I go through the outline and I don't have the answers yet.
Yeah.
So that's kind of, I want guidance from the committee and the subcommittee on how we deal with the playbook conflicts, in this scenario.
Well, I think that opinion, the ABA opinion did some good things. I think one thing I was wondering just about scenario A is like whether there could be a point, whether it's in a footnote or not, that just talks about sort of like that there needs to be a consideration of balancing like attorney mobility, public policy factors with respect to it, because I have seen in this context, and I'll just say very generally, companies wanting to be super aggressive about like, because you worked in-house for us, like you basically couldn't go to a competitor and do a job because you know information about our company, and therefore that would be unfair as a general proposition without getting into a specific conflict analysis, right? And so I think that's very problematic, and I would want to suggest, for example, like companies can't say, because you have some confidential information related to our company, that automatically you have to be screened from like every single thing that you do at your job, right? So that the screening obligation, for example, is triggered by, it's not potential future, unknown conflicts, it's a specific conflict, right? Now, you could talk about in-house like policies as whether it would be really helpful to protect screening and say like that you have to sort of say, hey, in each scenario, you have to get access to particular matters and things like that. But so I don't know if I'm making myself clear on that particular point, but I don't think you can just say because you have confidential information that basically you can't do your job at the new company, right? You can't do anything.
Well, is
And then-
that a restriction of what, I mean, we're not talking about a, 5.4, it's an agreement, that restricts the lawyer's practice.
Right, but so that could I guess that could sort of dovetail on that issue, but I think that I think some super aggressive companies could say, because you worked in this like particular department doing a specific thing, you can't now go to a competitor and do a similar thing. Now, there could likely be limitations on certain things that lawyer could do with those companies, but as a general idea, basically saying like, you can't do anything, you need to screen yourself out from like, generally because we think you're gonna improperly use confidential information. I think another thing to point out, which would be helpful here, I think, is to really emphasize that that person that moves over in analyzing conflicts, so former client conflicts that implicate the knowledge of confidential information, it's really important. I mean, I don't know how we don't want to get into best practices, that they discuss this with outside counsel, right? Because you then can't go to the general counsel and say like, hey, so I don't know, I know all this information about this, is that a conflict? And they're like, well, now I know all the information and now
Right.
it's been imputed on everybody.
That's a good point, yeah.
So I think this is one of those scenarios where it's really important that if that person who has confidential information from company A goes to company B, if there's questions that arise on a case-by-case basis, or in some capacity about whether it would, implicate a potential conflict, they need to discuss that with outside counsel, not, or they're
Not
gonna
getting
create
juicy.
more imputation problems for the company.
Yeah,
That's a great,
Yeah, that's a good
terrifying point.
yeah.
Can I make a suggestion here?
Yeah.
The Association of Professional Responsibilities Lawyer listserv for about the last 6 weeks has been beating
Yeah.
up the topic.
Yeah,
And-
the type of stuff. I know, I've been following that.
Yeah, and they, the last one I saw, and I haven't paid a lot of attention to it, but the last one I saw, it cited the Pennsylvania Supreme Court said it goes beyond confidentiality. It implicates loyalty as well. And there might be some authorities in there that if we haven't consulted it, that might be a good idea to do, and I'm not volunteering to do it.
No, I'll do that. I've been kind of following it too. I haven't been looking at the authorities, but it kind of coincided with my thought process on this, and so, but you know, I think it's controversial because the lawyer mobility issue is really important. So you can't just claim playbook, conflict, and
Right.
then nobody gets to move anywhere from
Yeah.
company to company. Yeah.
Very interesting.
So
So the only case that I'm aware of that deals with some of these issues, and it's not in-house, but Fair versus Bakhtiari,
what is it?
it's Fair versus Bakhtiari and all.
Oh, yeah.
And it's got like the most severe consequences for an attorney who works with the client. They become partners and stuff, but he does all the legal services for years and years. There's no dispute that he did a good job and it was profitable. He never complied with 300 then.
Right.
Boom, he's out. He gets like zero.
Zero of the stock. Yeah.
And he can't even sue for quantum merit. He can't do anything.
Yeah. No,
But I don't know how that could. But it can. It's
So
something.
that's like the second part. So right. So the question is do you have so let's move to the second part where you have stock options, or stock in the company, and does the in-house lawyer have a duty to comply with 1.8.1 when it's the company that's providing you this employment agreement, the company that has all the leverage, and the in-house lawyer is typically treated just as as an employee, like all the other like key employees or employees. And so does it really fit within the, of course it's fair and reasonable to the client because the client is the one who's proposing these terms. But I don't think that means that 1.8.1 doesn't apply. And the other thing about what I was thinking too is that 1.8.1 really, it's not explicit, but it really is intended to apply to, ownership or stock in exchange for fees or in lieu of fees.
Services.
Right.
Yeah, well, right, so in
Yeah.
exchange, so these aren't, but this isn't that, so it's kind of, it doesn't quite fit. And so the question that I have, I want to take a poll is, do you think it should always apply to in-house lawyers who are given stock options upon their employment? Should there always be, the provision of 1.8.1 in there where it's fair and reasonable, the client has, was told to consult with independent counsel, or do you think that's just exalting form over substance?
Well, it depends. Are you talking about as part of a compensation package before I become your employee?
Yeah.
See, if it's arm's length, I think.
That's what I think. I feel like it's arm's
But
length.
when like I've been with this startup for years and let's give everybody stock. You should give me some stock too.
Right. Yeah.
I would
then
say
I
they want to
agree.
comply with 1.1 or 1.8.1.
Well, that's interesting because
Yeah.
the Washington case that I found, and I didn't do a ton of research on this, but I did some to find out like what other state where this has been brought up. And it was I think it was a bonus structure that was given, or some kind of bonus. And the court said that 1.8.1 did not apply to that scenario.
Well, so here's another complication, because I know that there's all sorts of labor code provisions that I don't know anything about
Yeah.
that protect employees and their compensation, which probably are intention of
saw that.
1.18 or
Yeah.
1.8.1 now. I don't know though.
Well, should we be addressing how labor code provisions may conflict with an ethical duty that applies to an employee who's also a lawyer?
I don't know.
Have any other ethics opinions ever addressed this question about just like the original compensation package? My instinct is the same as yours, where I feel like that feels arm's length transaction.
Yeah, there's no attorney-client relationship
Yeah.
yet, right? So it's
You
like
haven't even decided.
yeah, it's not like, when I think of like a business transaction, it's like, oh, I've got this client and they wanna give me property for whatever reason, we're gonna have to think about whether there's a conflict, blah, blah, blah. But here, if there's no attorney-client relationship, you're just trying to form become an employee, become a lawyer, and you're getting a bonus as part of that. And you're not even technically an employee, let alone an attorney for the company at the time in which that transaction is. As opposed to, I think maybe Brandon said this, something comes up 3 years into your employment where they're offering you some new bonus structure or stock options or whatever, would that influence how
Or
you?
maybe you even advise them that that's a great
Well,
idea.
But I mean, but you're talking about like if you looked at it as like the analogous to a fee agreement that you have with some client that's not in-house, right?
Right.
If you said that that client was like, hey, we're gonna do some kind of arrangement where you can have an interest in my company in exchange for fees.
Doesn't that trigger 1.8?
It definitely would, and so then the
That's the
question that you're
analysis.
raising is why wouldn't it here, and I think it's an interesting.
So I'll just say, in this thing I vaguely referred to where we're litigating one of these issues, it's an attorney, worked at a company, and our view was the attorney advised them towards a business model that benefited the attorney enormously, with
Right.
an ownership interest. And then it was never a filed litigation, we're just sort of circling around it. And then the attorney, their position was labor code, man, you do not mess with agreed upon compensation, you're gonna get triple damages, you're gonna do all of these. I'm an employee,
Yeah,
and there was enough risk around that we came up with a.
so that's the question is that does the ethical rule trump the labor?
Maybe you
code?
could get disciplined, but you're still gonna win your labor code fees, I don't know.
Okay, so interesting question. Okay. But so that there's the ABA opinion that talks about the 1.8.1 applying to stock in lieu of fees in the law firm context. You know, if you're a lawyer with a law firm and engaging, you know, a client, so it's not in-house, but it's still 1.8.1, and it also talks about 1.7, whether it's a material limitation. And in that opinion, they say that the material limitation conflict does not typically arise if you're thinking, you know, just by virtue of taking stock in a client. Unless there's, unless it's, and this is kind of weird, unless the stock is like the majority of the lawyer's assets. So it's like you have such an interest in the ownership of the client. That would create this, you know, material limitation on your representation, or if, I forget what the other, it's in the outline. So, you know, I think the ABA opinion is good guidance, but there's some differences because they talk about like law firm policies about how much stock you can take and that sort of thing. Well, a law firm policy can't apply to an in-house lawyer, or can it, you know?
I mean, I also think it seems relatively commonplace for people that are going in-house in particular companies that stock could be included, that just like any compensation for executives in the company, right? So the question obviously becomes, is there some heightened obligation with respect to a lawyer or a person acting in the capacity of a lawyer for that company in their in-house department, you know, and if we don't have authority to strongly suggest that there needs to be a 1.8.1 type of disclosure, then I don't think we should suggest that there's one in a way that, because this is, I don't, you know.
Well,
I was just looking at, I was just trying to research it, looking in the Rudder Group guide here. And what they say, although it's a little bit different, it's taking shares in a client's business. It's a little bit different than the in-house as compensation, but to them, they treat it as a settled matter. It's
Yeah, no,
not
I understand
an attorney to accept compensation provided the attorney complies with 1.8.1.
right, so that's the scenario where, you know, you're taking stock in lieu of fees. You know, it's, and
Or
that's
it's part of your fee, but yeah, so.
part of your fee, right, so that's pretty clear, but here it's your compensation package with the company that's employing you.
I think it would be helpful for us to get some real world intel here. I'm happy to talk to some of my contacts, maybe some other people are as well, to get a sense of how this works in terms of real in-house lawyers, when they get stock options. Is it just like the engineer down the
Yeah.
hallway?
Right.
They just all get the stock options, it has nothing to do with their fees, that's
In
what the
my
company
experience,
does.
And I don't have a lot of experience, but that's what
So,
it is.
so let's
Yeah.
kind of get comfortable with that real world scenario, and then maybe we think about having to build in some factual assumptions into our opinion.
Okay.
That it is, you know, a fact in our opinion that the stock being provided to the attorney in our hypothetical is being given stock, just like the engineer, just like the contractor, and not in lieu of fees. It's the same package that stock package that every employee gets, assuming that that's consistent with real world to the extent we
Yeah.
need to do that, and then we can avoid some of these concerns about, is it in lieu of fees? Well, we can make clear that it's something that would simplify maybe the analysis.
Yeah, or
something like that.
conversely, we could say that our fact pattern involves a situation where it's like the person has been in-house at that particular company for 3 years and is involved in setting up, additional bonus for himself, some way that it's clear that they're utilizing their role as like legal
Right.
counsel at the company to then also negotiate with themselves for personal gain in a way that would be obviously something that would be require that disclosure as opposed to just, that scenario.
Right. Yeah, because that was part of like the old outline was that a big part of this is that the lawyer's wearing so many different hats, is that they're advising about the business and all that, and they lose sight of the fact that they, are also a lawyer and advising about things that impact them. So, okay, so I think that's good. And then the last part of the scenario is when the company is sold. And so one of the things that we talked about during our subcommittee meeting is that, okay, well, let's say you do all your conflict waivers at the outset. You have the 1.8.1 and 1.7 conflict waiver and you're all set. And and it's informed consent. So you disclosed presumably that, that the company may be sold and so, advice I give you about the company being sold will impact me personally because my stock will go through the roof, but maybe it's not a bad, maybe it's a bad deal, for the company for whatever reason. So they've covered all that. So then the next question is there a, if when the company is being sold, are there additional conflict issues to deal with for the lawyer? If they're going to be advising about the deal and whether or not to enter into it. And so I added facts to that to say that, we're talking about a closely held company. And so you've got, individual shareholders and the individual the shareholder group is coming to the lawyer saying, is this a good idea for us individually? And so then that raises, issues about conflicts between them and then conflicts between them and the company and that sort of thing. So I thought that was a good conflict issue to address separate from the stock ownership by the lawyer,
That's a challenging, I like it.
Yeah, I think it's good you have the second question really address the 1.8.1 and whatever iteration.
The personal conflict.
Right, and then the third scenario addresses like a 1.7 type conflict. The first scenario addresses more like a 1.9, right, former client. I think that's kind of,
Yeah,
right?
yeah. So we're kind of going through all.
But
There's almost a 1.13 concern too, when the closely held shareholders are asking you for advice. You
Right.
clarify
that's a good
things, too.
point, yeah.
Yeah, I think I
It's a great law school exam, I love it.
without answers. But so that was that, and then but there's and in my practice and in my research there's a lot of a big body of law sort of about conflicts and how to deal with mergers and acquisitions, and so the company is sold and the lawyer goes from buyer to or seller to buyer, because the company gets absorbed, and so what kind of conflict issues, you're basically, moving to the other side of the table.
Oh, yeah.
Yeah, but that, a lot of the stuff on that has to do with privilege issues and things, so I didn't really get into that, but I think that's an interesting issue as well, but there's more law out there on that, just in the M&A world, so. Anyway, that's the outline.
Just to make sure, for the playbook scenario,
Mhm.
have you read the Schlumberger case?
No.
Schlumberger. I'll send it to you. It's basically this fact pattern on steroids.
Okay.
It's the in-house lawyer who goes to a competitor, shares the information about the technology from the former company, and then in litigation, not only does that in-house lawyer get disqualified, but the
Yeah.
entire in-house department gets disqualified.
You know the case, yeah.
Yeah, okay. Yeah, so that's, so that's where we could draw,
Yeah, you can try all sorts of stuff from
Yeah,
from that case. I think that'll be helpful for the playbook analysis.
okay.
Well, I think this is in great shape. So in terms of next steps, what do you what are you anticipating?
Well, if everybody likes these hypotheticals, you know, we can get started with writing it. And you know, we can help. I think, Sarah and, Kyla are on the subcommittee, so we can talk about divvying up, drafting. And so I assume we would have, do we need a draft by the next meeting or?
Whatever's practical. I mean, we're realistic here at CoPrec, so, you know, do what you can. I think our next meeting is in September, right? No, August, so there is a good amount of time. So I would say, yeah, I think we should shoot to have at least a working draft for the September meeting. That
Okay.
seems feasible.
Brandon, I'd love to talk to you about your matter.
Yes.
I mean, get some.
No, and because I don't understand the labor code and I had a labor attorney, but I can at least find the provisions they were arguing contrary to the lawyer provisions out there.
Okay, you give me your work product.
Exactly, my undisclosed work product.
Okay.
All right, great. Well, we're right at 12 o'clock, right on time, so that's great. Why don't we come back at 1 o'clock? And we'll start up with the file retention questions that remain outstanding and then go from there. All right. Okay, welcome back, everybody. Hope you had a nice lunch. We're gonna start up again with 19,004. And we were talking about footnote 7. Hopefully, everyone had a chance to at least skim some of these ethics opinions that Mimi circulated for us. I just looked at one of them. Before I share my thoughts, I'm wondering if anyone else has new or different views that they want to share after reviewing the ethics opinions in terms of how we want to formulate this footnote 7. Okay, well, I'll tell you what I think. I just skimmed granted in 5 minutes, the 2001-157 CoPrec opinion. And footnote 3 of that CoPrec opinion, which is talking about files, what constitutes client papers and property that have to be turned over, already has a formulation from CoPrec as of 2001 on this question of uncommunicated work product. And it cites several cases for that statement. It says that the issue as to what constitutes client papers and property that must be released to the client is beyond the scope of the opinion, and notes, quote, there is an unresolved division in the authorities as to the client's right to receive uncommunicated work product of the attorney. To me, this formulation that CoPrec has already come up with, I think, is consistent with expressing that there is, as it says, a division in terms of whether and when uncommunicated work product has to be provided. And to me, kind of reinforces that we want to be pretty nimble here and not necessarily define what we think personally would be client papers and property, given that we've already issued an opinion saying that hasn't been resolved. So to me, this counsel's in favor of a very conservative framing of the footnote, not delving into whether or not uncommunicated work product, whether or when it would be reasonably necessary. I don't think we need to go there. CoPrec hasn't gone there in the past, as illustrated by this footnote 3. And how that ultimately goes into wordsmithing this footnote, for discussion. But again, I think we don't want to go further than we have in the past, particularly since we've already acknowledged this division. That's my personal.
Justin, the way I read this is kind of the same, this footnote 3 is kind of what we're trying to put here, that we're not delving into trying to settle this question, this unresolved split. But do I take your comment to suggest that our bullet point is incorrect with the reading that if it is reasonably necessary to representation?
I'm concerned that there is an inconsistency there. To play devil's advocate, I think it would be more precise for us to say attorney work product. Give the examples that we provide as to what constitutes attorney work product. And then have a footnote saying that there's this unresolved division about whether and when uncommunicated work product needs to be turned over to the client. And excise the reasonable necessity language, while at the same time citing the opinions that inform a discussion about whether and when work product should be turned over. That's my personal view. I know not everyone agrees with that, but that's my concern because of these differing formulations, both in our own COBRAC opinion for this footnote 3, and then also I very quickly reviewed, I don't remember, it was the San Diego or the San Francisco one that community circulated. And I'm not sure I saw the formulation in the same way as we've reflected here with respect to the reasonable necessity analysis. So my concern is mainly just not stepping further than the authorities would permit us.
Can I make, I don't know if I agree with you, but can I?
You're welcome to disagree, and I expect that many people don't agree with me.
No, but I mean, I don't know, I think that maybe a compromise is not to acknowledge that there's a dispute or an open question, but just to say that we're not getting into this question, or we're not getting into, I just don't want to open the door to there being an argument later on that it is one way or the other. I would rather say that we're not touching it at all.
I think that's the ultimate goal.
But not without saying there's an open question, because that is acknowledging at least some.
That might be the source of our dispute as to whether there's no. So we are not opining on the precise, I don't know.
I know. I mean, in my mind, I'm thinking like.
We're not opining on whether and when uncommunicated work product.
Just say that, we're not opining on that.
Yeah,
Without saying
cite the
there's no-
authorities, let
yeah.
people read more if they want,
Yeah,
something along those lines. It
without
doesn't have
saying
to,
there's an open question.
we don't have to, I can live with that,
Okay,
certainly,
that was.
as long as we're not delving into what the answer is to the open question, to the extent there is an open question.
Right, exactly.
How's that?
It may be, Justin, that we should basically cite ourselves then here and maybe say that the committee has previously noted that there is an unresolved issue here and we are not seeking to resolve it in this opinion.
Did we say that?
I don't really like footnote 3 in the other opinion. I don't know why they said the issue of what papers and properties must release is like.
But you see, this is my,
Because it's like they then go and list what's.
it's the same thing with the matter of Regan. We have these cases saying stuff that we're like, it's kind of not clear. We have our own footnote, which is maybe we don't think it's the best worded. And so it leaves us in this kind of quagmire of.
I just think you say we are not getting into without saying there's enough, because that's making.
This opinion does not address whether or not uncommunicated work product must be released to the
It's the
client
same-
upon the
it's-
request.
Yes.
It's the same way we address the UPL in the
That's-
other opinion, and then we cited all the ethics opinions, just do it that way, I think.
That seems like a pragmatic approach.
What does that do to the bullet point itself, Justin? Your thoughts on the bullet point?
Well, let's hear from other people on it, but the other, if we were gonna go down that path, I just wanna say that I agree with what Capsie said, it was like, I don't wanna say that it's an open question if some of us don't think it's an open question.
Right.
Whether or when type
I
of
don't think it's an open
formulation,
question.
I think avoids having to get into that debate.
Yeah.
If we have previously stated that it is an unresolved issue, would we be creating an ambiguity by having two conflicting opinions, or is this suggestion that we just not cite that at all? I don't know that creates an ambiguity, but if we've already stated that there is an unresolved issue or a split, I don't know that we can avoid it being an issue that we have to address.
I don't think they're inconsistent positions to say this formulation of, whether and when you have to turn over uncommunicated work products, I don't think that's inconsistent with that footnote 3 from the 2001 opinion, which says it's unresolved. I think they're related issues, and that by saying the formulation that Cassidy proffered, I think is it's not disingenuous with what the COPRAC has previously said. I think that they can be married, and that basically by going to the opinion from COPRAC or going to the other local bar association opinions gives the audience an opportunity to reach their own views on this issue without us taking a position on it, even if to a certain extent in 2001 we did take a position.
I'm persuaded that that's correct.
Okay, Hunter, would you say what you're persuaded of? Because I didn't fully understand it. I'd like to get somebody uninterrupted to state exactly what we're doing here.
If I may, and here's what I view the conversation has gotten us to. There is potentially a split of how we see the question of whether a client is entitled to uncommunicated work product. However, we don't want to weigh in on that question, so much so that we don't even want to assert that there is such a split, because doing so would be weighing in on that question. And so rather than acknowledging that there is a split or claiming there is not a split, we just say we're not going to discuss the issue of whether uncommunicated work product is something the client is entitled to. And that's it. Leave it at that.
Then I would disagree with that. I think that if COPRAC has already weighed in on it, and we ought to cite to that and just say that we previously discussed it and we're not going to discuss it again.
Are you saying that Hunter, that without reference to whether the uncommunicated pieces of a file are not, even if they are reasonably necessary to the client's representation? Because it looks like the San Diego opinion makes that differentiation in terms of evaluating each case on its own merits.
I agree. I wanted to chime in too, because I disagree. I looked at the 2001 opinion. So 21 years ago, the committee took the opinion that what must be released was beyond the scope of that opinion. So they didn't opine on it. Why do we have to follow that? Why can't we take a position on what must be released? The fact that the committee 20 years ago chose not to do that, I don't think in any way binds or limits us. And I think it's something that's worth being addressed.
Well, yes and no. I mean, the footnote 3 says there's an unresolved division in the authorities, and that is still true today. The opinions that are cited here from San Diego Bar Association and Bar Association of San Francisco are even older than the COPRAC opinion. They're from the 90s. And so I don't think that, again, I don't think that let me rephrase it in the positive. I think we're having this conversation because it's still, at least in some people's minds, maybe just mine, that there still is an unresolved division, as we said in 2001. And that there is no clear answer. I mean, our COPRAC opinion came after these local bar association opinions, and we still said that. So again, I think we given that there is still this tension, lack of clarity, however you want to phrase it, I think we avoid stepping into something we don't mean to by being clear that we're not going to be the entity that decides this open question that courts haven't even resolved. by the formulation that Cassidy suggested.
Speaking as a consumer of these opinions from time to time, I like to be able to read them and know that I am going to be avoiding any danger out there. And if there is a topic area that presents danger, even if we're not going to resolve the danger, I'd sure like to know about it.
I mean, I agree with your comment, Ken, about the fact that I don't see the reason, because it wasn't resolved in 2001, that we can't resolve it. But I mean, I actually kind of go back to what we have, which is like, if we took out in the bullet point, if we took out that last clause and whether or not communicated to clients, right? We just say work product reasonably necessary to the representation, because I'm comfortable with, and we can take out the communication. Then we have a footnote 7 where we say attorney work product, and we don't have to say it's part of the client file, but we could say must be released pursuant to Rule 1.16E1 if it is reasonably necessary to the client's representation, because that's clearly what the rule says. And then we say, you know, this other question, I mean, we can go back to what we have, which is whether or not it's previously communicated as I'm comfortable saying it's an open question, and it depends on whether or not it's reasonably necessary or not. That's just a fact inquiry. Is that, I mean, I don't know. I kind of go back to the original formulation, taking out the citations to Rose, and you know, and if you want a clarifying sentence or not, I don't know.
Can't you just say, I mean, the San Diego opinion says the issue of what information is reasonably necessary to the client's representation in particular, and what information might result is reasonably foreseeable to the client if withheld in general will differ depending on the circumstances. Can't be that be the footnote and then just cite the San Diego opinion? I mean, isn't that?
That's kind of what we do, except we just say instead of saying will differ depending on the circumstances, we say involves a fact specific inquiry, but we could certainly say what.
Well, but that's, I mean, I'm fine with that footnote, because that's not I mean, in my mind, work product can, I mean, we're getting back to the same discussion.
Yeah.
But, you know, work product can be withheld unless it's reasonably necessary, or withholding it will be prejudicial to the client. That's not an open question to me, but it sounds like people are saying, no, everything should be produced.
Well, and is there anyone that thinks that you can withhold, you don't have to release something to the client that is reasonably necessary to the representation?
You don't have to. I'm not. I
Well,
don't.
for
Anything,
me,
yeah.
let me play devil's advocate, because that's what I do. I think that sounds correct, but I don't read 1.16E1 to say that, because it doesn't talk about work product in the way that we're saying that it does, or we're suggesting this footnote that it does. And then couple that with the Regan case and our own footnote, and it gives me pause that there isn't clear authority other than these local bar association opinions from 20+ years ago to support that statement. So what sounds right, my concern is that we also have this tension in authorities and our own footnote suggesting that there's this unresolved situation with uncommunicated work product, and that those discussions about uncommunicated work product don't tie it to reasonable necessity. All that makes perfect sense pragmatically about reasonable necessity, but it's described more black and white without that nuance of reasonable necessity when it comes to uncommunicated work product. I'm not saying I agree with that. I'm not saying that that's the right conclusion, but I'm saying I'm concerned that we would be stepping too far by and potentially creating authority on something that isn't presently supported by persuasive authority.
So what the reference to other items in 1.16, there's a question of whether that encompasses uncommunicated work product, or uncommunicated work product actually belongs in the list of what's identified as client property and materials, whatever.
Right, so and I
think
could
so.
be completely wrong.
I
Yeah.
think it has to be.
If there's a case or something that says 1.16E1 other items, property, this encompasses uncommunicated work product, I'm sold. But I'm not aware of that authority.
But it's the plain language of the thing that says all of these things plus other items that are reasonably necessary to the representation. The entire ballgame and argument is like, what's reasonably necessary? And you have a great argument to say that your own work product about whether you think your client wouldn't make a good witness and your assessment is not reasonably necessary to the well, I shouldn't give any examples, but that's just a factual argument, right?
Yeah.
So I don't think, and that's where I don't think we're going out on a limb by saying the rule says this and how to
But what-
determine whether or not that's reasonably necessary is not something that.
What's another item that's not work product that could fall under that definition? Like what you're,
Yeah.
Can you be?
Website article or like,
Could- Oh, that's not work product?
that's not work product.
Could you say, oh, I took a deposition of this person that
Right.
had no bearing on the case, so I'm gonna call the file?
I think one of the reason why I told Justin that I was persuaded by the position that he enunciated is because the opinion has a very specific purpose. And it goes back to the issue statement that we formulated. I think to solve this question or to discuss something that has been phrased by courts as being an unresolved issue in a footnote is a bad idea. If we wanted to address the question, it seems that we'd have enough to talk about for an entire opinion potentially.
Yeah.
But if we're going to be addressing it, we should be addressing it head on or not addressing it. That's why I was persuaded by Justin's conservative approach. It's not that we have to take a certain conservative approach. It's just that I think that's the best idea when the opinion is not about this very narrow question.
No, but I respect that position. I think to Joel's point and other points, work product is something you're always thinking about. The biggest question about what to turn over to a client in a client file is not like, should I turn over a deposition transcript? Because it's clearly that's part of the definition of the rule. Or should I turn over pleadings? Or there's some stuff that's kind of a no-brainer because they're specified. I think attorneys looking for guidance, work product is obviously one of the things that they think about and say, and so to give them a framework for saying like, okay, how do I analyze whether or not this is reasonably necessary? That's a standard for them to give them guidance. I think to say, we're not going to say whether we're not going to address this at all seems to me like, I don't know, it feels like a cop-out. I feel like at least we need to give them a roadmap and say it is unresolved or it's an unresolved question so that they can navigate it better. Because it's an obvious thing that people want to know about, and I don't think it needs to be a whole opinion. I don't think it needs to be more than what we've sort of said and reworking it in a way that the majority of us are comfortable with, but I am persuaded that I don't want to just say, okay, work product is something, but we're not going to talk about it. I don't think that's super helpful in an opinion about, file release duties.
Yeah, no, I totally agree. We have to acknowledge the elephant in the room and that there is this clear tension. If I'm remembering public comment correctly, there was a lot of competing views on this very subject. So it's obviously something the audience who reviews our opinions is paying attention to, which to me, all the more reason why A, we need to say something in the footnote, but B, I'm just personally not comfortable taking a side on what, at least to me, does appear to be a debatable question for reasons that are beyond our control and for which, from a normative perspective, we may all agree in this committee. So what I would propose as a next step here is to draft the language that Cassidy had suggested, or I'm giving you credit for, about the concept being that whether or when uncommunicated work product needs to be turned over to the client, or however we're going to phrase it, is beyond the scope of this opinion. And I think we still need to cite to the bar opinions, our own opinion, and just the Regan case, so that the audience can draw their own conclusions from.
To that point, what if we just said there, whether and when a lawyer is obligated to release work product not previously communicated remains an open question and involves a fact-specific inquiry. You're not comfortable with fact-specific
No, I'm fine
inquiry.
with that.
I mean, what if we just change that part there? I mean, the other thing is that this is gonna go out for the round of public comment, and so we could make some changes now so we can get it out because it's been on the burner for a while. And then if people come back and be like, this is, and we get a lot of feedback about this footnote, which we did before, and people aren't comfortable with it, then we
I'm
can
comfortable with
consider.
that. I think that addresses everyone's issues.
Okay, so to that weather
It's
point,
something-
Angela, is it you or Mimi doing that?
I would just
I'm
say,
doing it.
this opinion does not address whether and when a lawyer has a duty. I don't like.
You don't want the
bringing
open
something-
question part. I'm okay
That's
leaving
fine.
that out. I think, do you feel that that's?
Yeah, this opinion does not address whether and when, wait, so, sorry, put it in the, where that sentence that starts whether and when, whether a lawyer, just as a red line, if you could do it as a red line.
All marked up. Yeah.
Oh, yeah, because we
It's
marked
split.
this up a lot.
No, that's weird. So,
This opinion does not address whether and when, which we already sort of have that. or-
Do we need when or just whether?
Well,
And when.
pre-litigation, after litigation, yeah, when
That's
is
fine.
it?
When?
Or under what circumstances?
Yeah.
Under what circumstances could work too. Doesn't address
How about
under,
when? I like when, when's just, that
okay,
makes sense.
whether and when a lawyer is, and then leave that, a lawyer is ethically obligated to release, what do we have? Not communicated and involves a fact-specific inquiry. And then we take out the site to, we're definitely taking out rows, correct?
Yes, please.
plus the parenthetical.
Yes.
And then we're taking out that bottom sentence, right?
The highlighted in green?
Or is that what you decided to add that?
I still like it, but I wonder if it's still necessary after this.
Okay, and then
What do
we,
you guys think?
and then on the bullet point, and let me just make, then we can talk about it, the bullet point. We're gonna stop, sorry, right above, we're gonna take out that part and whether or not communicated to the client, is that correct? We're just saying,
Yes.
okay,
Do you still want to take out the?
yeah, that part, yeah.
I hate to throw a wrinkle in here, but doesn't this construction sort of imply that the only circumstances under which a client is entitled or there is a duty is if it's reasonably necessary? Which I sort of read it this way, but I sense the committee isn't in agreement on that, and I feel like we're implying that's the case. So I just
Yeah, well, the bullet point.
flag that how I'm reading it.
I think you're right, Eleanor. I'm not a fan of the use of reasonably necessary for the reasons I've said, and I know that many folks agree with me. So if I'm overridden, that's fine. I appreciate we want to get this out for public comment, but I agree with the observation. For that reason, I would personally. be
So you
interested in
guys
that.
think it should just say attorney work product and then,
And like the other, yeah, sorry. But yeah, I was thinking, like, to be consistent with the other bullet points.
Yep.
Say attorney work product, and then give examples of what attorney work product is, and then our footnote.
I don't disagree, but I'll just make the point that if someone's quickly looking at it, they would think all attorney work product needs to be turned over to the release to the client.
Instead of
I
saying,
agree,
why
I
don't you
agree.
just say other items then, be completely consistent with the rule? And then put attorney work product in the footnote and talk about it. I mean, that
Yeah.
technically, I know, it makes no sense because the rule is stupid.
Yeah, I mean, it would be nice if the rules. that other
Can we just
items
say that?
include product, And then we could do that.
I know, but we're going down this path
Yeah.
of, you know, let's not touch anything, let's not interpret the rule in any way. And we cannot, you know, I mean, we don't know what to do with work product is the problem. And so by putting it in,
What if you know, nobody has to like this, but what if the footnote 7 came right after the phrase attorney work product? So that the audience goes
Yeah.
right to, hey,
without reasonably necessary after it, yeah, so we take out reasonably necessary and put.
put the footnote right in attorney work product, and then just give the examples, research notes, blah, blah, blah.
Oh, you mean put,
I know what you're saying.
yeah, I put the footnote 7 after work product and then research notes still stays in the bullet and then the footnote. Is that?
So attorney work product, and then
footnote?
immediately there, footnote 7, right
Yeah.
after product.
Yeah.
So that the reader goes right to our clarification about what we mean by work product and whether or when it has to be communicated.
I would be okay with that.
And then we give our examples of what work product could
Yeah.
consist of.
I would be okay with
What do you guys think on Zoom?
that. I don't love it, but I would be okay.
I mean, there's no right answer here,
There isn't,
unfortunately.
there isn't, I know.
I'm not entirely sure I followed the last one. Could you repeat that? I apologize.
So a couple things. One, we're trying to make this bullet point parallel with the other bullet points. So
That I followed, yeah.
So it'll just say attorney work product, and then we'll give examples of what attorney work product could consist of. But then to sort of
Right.
emphasize for the reader that we have this sort of caveat about attorney work product, we're moving the footnote to come right after attorney work product. So that to emphasize this kind of clarification we're providing, instead of having that footnote come after all the examples of what might constitute work product.
I like it. I like the
Okay.
change.
I think that's, yeah, I do too.
Shouldn't a rule is reference to other items at all in the footnote? I mean,
I understand the pull to do that. And I just come back to, and someone smarter about ethics rules than me maybe has an answer, but I don't know enough about whether other items is interpreted to encompass attorney work product.
On that first sentence in 7, the footnote, should we say attorney work product should be released to the client if the information is reasonably necessary to the client's representation, instead of say it's part of the client file?
Yes.
yeah,
I will regret this in every argument I have with defense counsel.
no, so thank you, as defense counsel, as a representative of the defense counsel.
Dina, can you?
It's part of the client file, and then cut it, and then just say if, so cut out the, sorry, should be released to the client, sorry, take out file is part of the client file.
You get it in litigation, Brandon.
I know.
And that's what I tell my clients.
Right.
is You're gonna turn it over
Well,
anyway.
yeah, because half the time I'm like, are we trying to mediate this? Why don't we
Yeah.
share it so I don't have to sue?
Every time, I mean, and it's like, look, if you have nothing to hide, just, it's fine.
All right.
And add a period after the word at the end of that quotation mark thing for the first sentence. Right there, yeah, period.
All right, how do people feel about this?
Can we live with this as our footnote going out to public comment?
Did the last sentence make it into the footnote? That last sentence at the bottom?
It was highlighted green. Yeah.
Okay, I'm good.
On the bullet point, I mean, I don't remember how it read before when we got all the comments about work product being part of the client file that has to be released. Seems to me if we take out the reasonably necessary stuff, we're just walking right back into that. I think that was the nature of the comments last time.
Before we said communicated work product, and then it felt like we were saying, I don't know.
Well, no, if you go up to before the first bullet point, it says, while not exhaustive, the following items are typically considered part of former client's file for purposes of release to the client at termination of representation. That's dealing with the release issue, and people had issues with the work product being part of the file that had to be released. I thought, I don't have the original draft of it, but I thought that's why we had the reasonably necessary and all this stuff to address those comments.
My recollection, Ken, was that we had a number of comments that basically said they wanted us to tell them what our basis was for saying that uncommunicated work product would not be the client's property.
Did we have uncommunicated in the prior draft? though? That's what I don't remember.
It was because of that reference.
Sorry, go ahead.
It was because of the reference to Rose and it being an open question.
I thought we added that after the last, that footnote came in after the last series of public comments.
We seriously revised the footnote, Ken, after the public comments, but that footnote was twice as long before the public, in the original version. So we tried to clarify that because we had suggested there was ambiguity about whether we suggested that uncommunicated work product never had to be released to the client. And so there was a lot of people that said, well, that's actually not true. The standard is whether it's reasonably necessary, and here's this and that. So we were responding to that in these revisions, if I recall correctly.
I don't know. Are we voting this out today or are we?
Public comment. We're going out to public comment.
Yeah, public comment again.
Dina, to your edit on the first sentence of the footnote, should be released to the client or must be released?
Or shall, it's the drafting convention.
If it's reasonably necessary and they request
Isn't it shall, should it be shall be?
It should be shall, but or must. I don't know.
Yeah, shall, good point, yeah.
Shall's,
Must or
I
shall.
think must is better than shall in this instance, because shall sounds like we're writing a rule.
Oh, is that right? Is that?
Just sounds like.
And then it still says open question in here. I don't know
Oh,
if the group agreed.
where does it say open question?
Line 5 of the footnote.
Oh, yeah, thank you. Take out the remains an open question, yeah.
Mhm.
Thank you. Yeah, I couldn't see
It's
it.
hard, it's because the captions come right where the text is.
Yeah,
Oh, yeah,
Thank you.
could you scroll that? Perfect. What was it?
a little bit down.
Yeah.
Thanks.
This opinion does not.
I thought we were gonna say is beyond the scope of the opinion or something like that.
There's just the last line.
Yeah.
Well, oh,
On a different page.
Is that
If you
somewhere
scroll
else?
farther down to the next page, it says it.
Oh, okay.
Right. Is that what you?
What,
No.
I don't want to say beyond the scope of the opinion, I just want to say the opinion doesn't address. I like
Okay,
the way it is now.
that's fine, but does it say that?
Yeah,
If you scroll up?
scroll up, sorry.
I don't think it does.
Yeah, no.
What if we said this opinion does not address whether a client is entitled to receive uncommunicated work product in circumstances where it is not reasonably necessary to the representation?
I think that sounds great, or might result in reasonably foreseeable prejudice, but yeah, I like that formulation.
I'm kind of lost.
Could you restate it, Gina?
Well, no, Eleanor restate it.
Sorry, Ellen,
Sure,
could you
this
restate it?
opinion, I can restate it. This opinion does not address whether a client is entitled to receive uncommunicated work product in circumstances where it is not reasonably necessary to the representation. And I think you add it. Or might result in reasonably foreseeable prejudice to the client if withheld.
That goes after.
Do you want me to text it? Is that helpful or?
Closed caption here, oh, no, it just disappeared.
Where do you want me to put it? In the footnote?
Can I ask a clarifying question? Is that instead of this opinion does not
Yes,
address?
Yeah,
whether-
yeah.
Yeah.
So it's reversing it. Instead of whether a lawyer is obligated, it's whether a
So
client is
we're
entitled.
Right.
just this
yeah.
sentence, this opinion does not address, we're gonna address that sentence.
It's just revising that sentence slightly, yeah, the first part of it. You're gonna probably have to say it again,
Fine.
Eleanor.
I'm going to text it, although I'm not texting it with quotes or cites.
Is entitled.
We can add that in.
I know. Carol's been in person. But we do need to get this back out for sure.
Yeah. Well, I thought the old days.
And then you would take out the after lawyer. Through release, I think is what they're trying to accomplish. So keep received. And then release. I think that's.
It's not communicated, not communicated to the client. And what did you say after previously not communicated to the client and involves, are you okay with that sentence as revised, Eleanor? And is that what you said?
Yeah, I just called up the public comment version.
You put it in the chat,
last
Ann.
time. And what it said in there was that work product communicated to the client was part of the client file. So that was in there. We added, I guess, whether it was not communicated or not or uncommunicated or communicated. The prior version said work product that was communicated should be provided, should be part of the client file that's provided to the client. And I'm guessing that's what generated those comments. All I'm getting at is I think we ought to go back and look at how we got where we are, because I get a sneaking suspicion we're going right back to where we started with these revisions. And it's not fixing the issue that generated the comments last time.
That decision. Well, I think, you know, that if that is the case, that previously we said communicated work product, it feels like we're tackling the issue, but I doubt we're going to leave all of the public commenters satisfied by our footnote.
Yeah, the way it read last time was attorney work product communicated to the client in the course of the representation. That was in bold.
Right.
And it said hyphen research notes regarding witness strategy, ethic, and similar items generated in the course of the representation and communicated to the client. So that was the bullet point before.
So yes, and I have some memory that the public commenters on both sides wanted us to take a firmer position and say
We had matter of Reagan cited in the footnote. Looks like we added Rose after this. So the footnote last time said attorney work product may be part of the former client's file if the information is necessary to avoid reasonably foreseeable prejudice to the client. And it cited the San Diego Bar opinion, a LACPA opinion, another San Diego Bar opinion. And then we said whether uncommunicated, well, I guess this was the title. It said whether uncommunicated lawyer is obligated to release the client to the former client attorney work product not previously communicated to the client remains an open question, citing the state bar opinion in the matter of Reagan.
So we're basically where we were, but with a formulation that we've, I think, fleshed out much more, and with the benefit of knowing that public comment is kind of on both sides of this this issue. To me, I still think that we should send it out for public comment, because I don't think that if we spend more time on this, I think we're going to come out very similar to where we were before, as illustrated by the fact that we're kind of saying what we did before, and the conclusion that we reached then as we are now is, I think we're not going to answer the what some of us think is an unresolved issue, but at the same time trying to provide guidance.
Yeah, I'm not suggesting it shouldn't go out for public comment.
Yeah, no, I think it's good for us to sort of prognosticate that we're going to get more public comment on this, and I think it's for the reasons that you said, Ken. And I just don't know that we're going to end up with a formulation different than what we had originally or presently, for the reasons we've discussed. But I think it's a fair point. Any other edits to this footnote? Because I do want to see if there's any other small edits that we need to make to other sections of the document before we vote on sending it out for further comment.
Ken had another area that he wanted to get to.
I did, but I resolved it in my brain over the break. I thought in our digest, there was an inconsistency between, in the first paragraph, we talked about how in civil files, it can be preserved in electronic form only if the lawyer believes, unless the lawyer believes physical copies that prejudice the client. And then in the criminal one, I thought we were saying, based on that statute, you can pretty much, if everything's electronic, we can keep the whole thing electronic, which seemed like a lesser standard, but I missed the last part of it. Says the nature requires physical forms such as physical evidence. So what I thought was a lesser standard for criminal versus civil is not. So I dropped that comment.
Okay. Any other comments outside of this footnote that we've spent a good chunk of time on? I just have one small one then. It was what was part of the red line 215 where it starts other file contents. Do we need the word not after will? Honestly, I can't tell, but I think we do. So someone else could read that. Should it say will not otherwise, or is it okay as is?
I think we might need a not. Eleanor, what do you think? You're a grammar person.
Sorry, I was on mute there. Yeah, I think we need a not.
I do too.
All right.
Wait, I think, I'm not sure.
But maybe
the
we
not
could,
piece-
let's,
We're in a tangled sentence.
Do you see
right?
that's a little
Tangled,
yeah, I think maybe we need to restructure it. Because the negatives are a little difficult.
Instead of does not believe, how about we change the not to reasonably necessary? So believes are not reasonably necessary or will not. I think that would be more of a,
I like
Or
that
who-
structure.
Or whose destruction will not otherwise prejudice the rights of the client. It's not the.
That kind of raises a question, though. I mean, now that I read it, is that a subjective belief? Are there any standards or factors that apply to the, whether it's whether it's reasonably necessary to the representation?
Reasonably necessary means objective, right?
Yeah, so it says the lawyer does not believe are reasonably necessary.
I mean, you're right, we should probably take that out. There was definitely some
There's a
formulations
question. Yeah.
in some of these other opinions, like including our prior one, that's had some sort of statement saying whether a lawyer has a reason to believe or things like that, that I don't think were the best formulation of the rule in that way, but I think that's sort of where that came from. But I would be in favor of what you suggest, which is that other materials and property that are not reasonably necessary to the representation.
That are not
would be just
reasonable.
there.
or will not otherwise prejudice. Yeah. Taking out the subjective
clean.
element. Yeah.
So, and we'll just take out that a lawyer does not believe and then put the not in front of the, between are and reasonable, right? Are we okay with that?
I think we should leave the that after property.
Other materials and property that.
Yeah, sorry.
Any other comments on the opinion?
As I'm reading that paragraph, when you go down to line 220 there, and it says, on the other hand, where the lawyer has reason to believe that the file contains items that will reasonably needed by the client or items required, the lawyer should inspect the file for such items. To me, that implies that if the lawyer does not think there's anything reasonably necessary, they have no duty to inspect the file before destroying it. I don't know that we want to say that, because I thought we said elsewhere that you kind of, one of the scenarios where you kind of have to inspect the file before you destroy it.
I mean, this is again, it's kind of quoted, but there's not quotations from our 2001 opinion. So that formulation of that sort of, the lawyer has a reason to believe or no reason to believe, that's from that opinion. So
So who was on the committee in 2001?
Let's write in the letter. I'm sure that, no, nothing.
Actually, I was on the committee in 2001, but I don't remember a thing about it.
Joel's at fault for all this.
Yeah, let's blame Joel. No, I'm not saying it's wrong. I'm just saying that I think that why some of these sentences were formulated a certain way reflects some deference to some of the language in that opinion. That's the only point I was making. And whether we don't like that, or whether it should be directly quoted, or whether it makes sense to quote it or change it.
Yeah, I just think, if you should always have a duty to inspect the file before you destroy it.
Would it be appropriate, do you think, Ken, for us to change that sentence that you pointed out to just a lawyer should inspect a file for items that will be reasonably will be needed by a
Yeah,
client?
I think that resolves it. 'Cause I think that is the duty.
But we talk about inspection later when we talk about destruction. I think we've talked about that later on in the opinion. And so I don't think you have a duty to inspect a file if you know 100% that there's things in the file that, the client's authorized you to destroy and you don't need to keep them. I mean, I don't.
And how do you know that?
Circumstances where you wouldn't have a duty to inspect a file because you've basically taken a file and you've looked at it at some point, you've cataloged it and you know what's in it and it's been inventoried, as opposed to throwing a bunch of things in a box and then later saying, I wonder what's in there. And we're talking about like an organized approach to, document retention where the firm knows what's in the file. So I wouldn't say in every single circumstance that they would have an obligation to, inspect the file if it's already known what's in the file, and at some point that was done in a very reasonable and conscientious way. And I think that's where the tension is. And we do address inspection duties later when we talk about destruction.
I guess that would be the issue. I think, in my experience with firms, when I tried to get files for malpractice cases or whatever, the retentions and how they've cataloged their files are somewhat lacking.
And then, Ken, if you, in line 331, we say, if the lawyer is without personal knowledge of the contents of the file, the lawyer is strongly advised to examine the file to determine whether or not there are items that must be retained, and we describe some things they could consider with respect to whether a document needs to be retained or can be destroyed. And I think that, I'm comfortable with the way we describe that. I mean, I think personal knowledge means at some point somebody had knowledge of it, the law firm has knowledge. Or we could take out personal and say without knowledge, but I just want to make the point that we do address it, and I think we definitely don't want to say that you always have to look at a file if it's been looked at some point.
The lawyer is strongly advised. That doesn't sound like an ethical standard. It sounds more like a risk management or. It just, I don't know. I keep coming back. If you don't know what's in there, I think you have a duty to inspect it.
Right, and here we say, if you do know what's in there, you don't, right?
Yeah, well, this is like if the lawyer is without personal knowledge, the lawyer is strongly advised. I guess, when I read this for guidance purposes, what is strongly advised? I mean, I have to do it. I have an ethical duty to do it. It's a good idea, practice point. That's.
Well, because, yeah, I mean.
I wanted to say, if you don't know what's in the file, you have a duty to inspect it before you destroy it, unless I guess there could be something in there unless you already have the client's permission to destroy the file without further inspection, something to that effect.
Since I don't think we say that,
Well,
and the opinion is pretty clear that they should be inspecting it without personal knowledge. I don't think this causes an ambiguity. I think if we didn't address it, it might cause that ambiguity, but we do address it head on. So I don't think that keeping the language that we have in there creates that ambiguity as to whether they have that duty.
All right, that's just my 2 cents. We'll see what the comments say.
Yeah, I mean,
can't you conclude, or can't we assume there would be circumstances where a lawyer could reasonably conclude that there's nothing in a file that could be prejudicial if destroyed or relevant to further? And let's assume you've got a really old file that's an employment claim, or some, the claim is of some type of nature that it's not going to be at issue again for the client, and it's 20 years old. Do you need personal knowledge? Is there a duty, or is it enough that you have a reasonable basis for the belief that there's nothing in there of any value to the client, or that meets these standards?
yeah, I agree with that. I think that's why we decided we weren't comfortable with saying there was a duty to inspect, and I don't think that's.
I thought I just heard the opposite. I didn't think I read that, but I thought I heard it. Okay.
But we could change the language, but we don't want to say if you don't know what's in it, you have to inspect it. 'Cause
Yeah,
that's-
I don't think we want to say must or shall. I think strongly advised is sort of a synonym for should.
You should know, or have a good basis to know that, yeah.
Right, because you're making a determination about whether it must be retained or whether it's would cause prejudice, and the best way to probably do that would be to consider these issues. And this comes out of some, I think it was the San Diego Bar Associations or somebody's public comment that suggested we could provide some some criteria that people would find helpful to evaluate whether or not a particular item should be retained or could be destroyed.
So thinking about Eleanor's, I think good real world example, frankly, and Ken's concern about the strongly advised phrasing. I'm just thinking out loud, what about instead, if we said, if the lawyer's without personal knowledge of the contents of the file, the lawyer should consider whether to examine, because there might be circumstances, as Eleanor pointed out, where it's so obvious that the lawyer doesn't have to go and search out some employment file from 30 years ago. But at the very least, the lawyer has to have that consideration happen in his or her mind. If he or she has no personal knowledge. It's not to say that the lawyer then has to go and actually examine the file, but at least consider whether to.
I think that's great.
Yeah, maybe you should evaluate, or yeah.
So, did you want me to repeat that?
Should consider whether
So
to
the lawyer should consider whether to examine.
And then we move that strongly advised language, which I agree, Ken. I mean, it is a little bit, I don't know, that's not typically how we would phrase something.
And then should add the two back.
What do you think about that, Ken?
Yeah, I mean, I'll go with that. I'm not opposed with saying you ought to look at it. I think that, but I'm clearly outnumbered on that one, so.
We're all about compromise here, consensus.
That's my compromise. I'll give in.
Perfect.
The thing because, even with what Eleanor was talking about, you just don't know what's in there. Let's say it's an employment case and you got a stock certificate as a piece of evidence and everybody forgot about it. And it's sitting there in the file for 20 years. You don't know about it. I've seen stranger things in files over the years when I get, underlying case files. So, but anyway, I'll accept the compromise.
All right. Any final comments or edits before we take a vote on whether to send this out for further public comment? Does anyone want to discuss this opinion for another hour? Okay. So.
Can we vote?
Yeah. So.
On which question? Just kidding.
So I'll make a motion to send 19-0004 out for further public comment. Erica, Angela, Mimi, do you guys have thoughts whether it should be 45 or 60 days? This is the second round, I think.
I think it has to be 60, right?
60, typically.
60 days then.
Second.
Okay, I'll take the vote. Justin Fields,
Yes.
Ken Bacon,
Yes.
Sarah Benola, Elizabeth Bradley, Cassidy Shivers. Yes. Toby Inlander,
Yes.
Brendan Krieger,
Yes.
Joel Mark,
Yes.
Eleanor Mercado,
Yes.
William Munoz, Kyla Rowe, Hunter Starr.
Yes.
Okay, so motion carries. 8, yes.
Great.
All right.
Well, thanks, everyone. Good job. It's a good discussion. It's an old school co-prac discussion, taking about 3 sentences over the course of 3 hours. It's bringing me back some fond memories. So next on tap, we have 20.005 conversion clauses. And I'm very excited because this seems like most, if not all, of the challenging points that we raised and discussed in detail last meeting have been kind of addressed.
Well, don't
So,
jinx it.
Trying to be positive here, so maybe Brandon, if you could just take us through the latest changes, where we're at.
Yes. So there's really only 2 areas. There was a little bit of substantive changes, cleanup I did. Wordsmithing and such. I'm not really exactly sure. I think I might have submitted like a messed up red line. So this is more, this includes changes we already discussed at the last meeting. I apologize. So I think there's really only 2 areas that we really focused on. Let me find them. 2 substantive areas of change. One was, oh my goodness.
Are you in the red line of the clean version?
I'm in the red line. And, all right, so I found the second one. Where's the first one? It is the, all right, at line 122. At line 122, we went from a really hard line position where we had the drafting committee, we had thought, the committee's opinion is that this is never ethically permissible, to likely to be ethically permitted, likely to be prohibited. And we explained why, because it improperly burdens a right to discharge the lawyer. This was, really contentious in other meetings, and I think it's a compromise on the language that I might have lost it and not know exactly.
Wait, Tramamba.
I'm not sure if it's still.
Go.
If it's still contentious.
You're missing it.
Maybe.
Sorry.
It's like something on her 25th hour of being awake.
Right. So that's one of the big substantive areas. One of the 2 is it from the paragraph from 122 to 126. And I'm wondering if people are comfortable enough with it now to invite public comment and the skewering that I may be coming from the public, but we'll see. It was the drafting committee's hope that this would be compromise enough.
And there was a second.
There was, yes. So the next one is at line 176, and it's still highlighted. And what we did there was we backed off of a statement that the client's informed written consent is required, because although we think that conceptually makes good sense, it's not tethered to a particular rule requirement. So we put in something that seemed reasonable to us as well. We're talking here at 176 about the really rare circumstance where you could have a conversion clause that is triggered by a client's settlement decisions. Highly unlikely to be okay, but there are certain circumstances where it might be okay. Where, and we talked about, we've got one hypothetical where we found it to pass muster or be likely to pass muster. And I cite in here to a LACWA decision, which referred to a public interest law firm that made it clear with their clients, like, we'll represent you for free as long as you don't agree to a confidential settlement, because the whole point of what we do is to make this good law. And if you agree to a confidential settlement, then you pay us our hourly rate. So that sort of thing, and which is unique, passes muster. And we're trying to describe the circumstances in which a conversion clause that is actually keyed off of a settlement decision could be accepted. And so we came up with some language here that we thought would adequately protect the public, or protect the client in these circumstances. Because we can all envision all of the terrible circumstances where a conversion clause keyed off of a client's settlement decision really invades the client's right to decide the goals of the litigation and when to settle. So we, in number 3, had, I don't think it's unreasonable, but it's new language. And that's really all we did for substantive changes in this round.
Great, well, does anyone on the subcommittee want to offer any further thoughts before we open it up to the?
Yeah, Brandon?
Yeah.
Brandon, first of all, in line 178, we got too many Bs, but anyway, should reasonably be.
Oh, I couldn't get enough of that though.
But maybe Brandon, if you could kind of just fill everybody in on where we got the formulation of that language. It wasn't just out of the thin air.
No. It was it from Rule 1.15? Where did we get it?
1.4b.
Yeah.
Yeah.
I mean, I think we should cite to 1.4.
It was the language in the rule that talks about how you communicate.
Right.
Adverse interest to the client.
Oh, we got it from 1.18. Sorry, 181. Yeah. Sorry to move that blank. So, and it's not quite an adverse interest, and that's why the informed written consent is required. But it seemed to be a reasonable formulation for the way it needs to be communicated.
What if we reference, since we decided it doesn't implicate 1.8, what if we sort of had that formulation? And I feel like you could try to collapse 1 and 3 there, and just sort of the goals of the representation and the alternate payment arrangements are communicated to the client, like tied to 1.4b and then cite to 1.4b. Like you explain the method.
Yes.
To make an informed decision regarding the representation, like that 1.4b site, and make it tied to that rule.
That's a great suggestion, because 1 and 3 really aren't distinct. They are closely related.
Yeah, because if we did, which I'm trying to remember, but I feel like we decided that it didn't implicate 1.8, right? As a group, we kind of felt like that wasn't. So then, but you still have that duty. But I guess this relates to that fact that like this whole discussion is going back in a loop of like, it's not really your client yet, because it's like you're forming a relationship, and then do you have this duty?
Right.
Yeah.
And the issue here, so it's not 1.8, but it is.
Yeah.
You still have but you have a duty to communicate fee agreements in a way that people can understand, and this is fits there. What if we did collapse? We got rid of 3 and just modified 1 to say are clearly understood and agreed to in advance after having been communicated in a manner that the client should reasonably understand. Something like that. I don't know. I'm just, and you might be able to tell I'm kind of like not married to any of this language. I just think the concepts.
Well, no, I like the concept, and I agree with the concepts.
Yeah.
I there's always that sense where I want to cite to a rule and say like you have the, and what strikes me here is like the duty to communicate the matter so that, clients can make informed decisions regarding the representation. But that question is whether that's triggered by at this stage when it's, right, because this is sort of
arm's length
the arm's length point, yeah.
If you're going to collapse those, don't you have to put in, after having communicated to the client, wait a minute, the goals of the representation and the alternate payment arrangement?
Yes. Yeah, definitely. Toby, thanks.
Yes.
Can someone read to Angela what we want this to be?
Yeah, that part out, Angela. On 1, the goals of the representation and the alternate payment arrangement are clearly understood. Well, I don't know if we should say clearly understood because we don't know whether they're understood, but they should be clearly communicated.
Are clearly agreed to after having been communicated in a manner reasonably necessary or?
Or you can just say the lawyer explains the goals of the representation and the alternative payment arrangements.
Not to mess all this up, but I don't know that I agree with the thinking that 1.8.1 does not apply. I mean, I still think it's something that could require informed written consent because I mean, under the rule, it doesn't apply. I think one of the comments, rule 1.8.1 doesn't apply to the initial fee agreement unless it conveys a security or other pecuniary interest. And I guess my view would be is if you're hedging your bet and you're putting something in there that, you know, in a contingent fee agreement that protects your fee in some unusual way, that's essentially a security interest.
I think that would apply if you got a lien under the Fletcher v. Davis.
Well, no, I wouldn't in a contingency, but I mean, to me, it's analogous to that. You're saying, if you're structuring your fee agreement, a contingent fee, such that if the client terminates you or you, well, I guess, let's focus if the client terminates you, you will get some alternate payment arrangement aside from quantum merit. I mean, I kind of view that as a security interest that could trigger 1.8.1.
Yeah, but Ken, the other side to that, where I don't agree with you, is that it doesn't create a readily, you don't create a possessory interest or a lien interest or some other way of foreclosing on that debt. It is just a contractual debt. So you're not getting that possessory interest that the other section talks to.
Does anyone on the subcommittee remember what these other bar association opinions that are cited about conversion clauses have to say about whether 1.8.1 applies in this context? Do they address that issue?
No, they address the client's right to determine the goals of the representation and to settle when he or she feels like it's appropriate.
So we
And not penalize.
don't have any other prior ethics committees to
I don't think
consider how they came out on that issue.
And so in our scenario number 5, we have a pretty complicated scenario where.
Can we, excuse me, I think if you, the language is off here under 1 and 3, it's not working.
It is. I think it should be something like the goals of the representation and alternate payment arrangements are communicated to the client to permit the client to make an informed decision regarding the representation, but that would be sort of a mirroring point to 1.4.
Right.
Which we would have, which we would have to decide whether we felt that was appropriate, but.
I think it's appropriate.
I mean, we can either try to mirror it and not cite to it, or we can cite to it, and then there's gonna be the question raised. I feel like if we don't cite to it, they're gonna say, well, what's the authority for that? And if we do cite to it, we might get an argument that is that really implicated yet in sort of a pre-client relationship.
Right.
Maybe to a prospective client, in that context.
Right.
But.
And I also think that the language, if you could transfer use the language somehow about being both understood and confirmed by the client is useful.
So we just need a much better clause or two.
Yeah.
Correct.
And since I drafted the one that doesn't work, I volunteer someone else.
Well, I will say on 1.5B 13, and we probably already talked about this before, Brendan, but like, Brandon, sorry, is whether the client gave informed consent to the fee. So that's a sort of metric of whether it's reasonable. And obviously, we know what informed consent, that you have to explain something that says someone can, to the extent that they understand it so that they can give informed consent. So
Maybe that's already solved.
yeah, so I mean, that doesn't mean it's required, but it's one more metric to demonstrate in this situation where you said it's gonna be challenging to navigate it in a way that makes it compliant with that rule. Informed consent would be something to show that, you know, would weigh in favor of allowing it
Right.
in this circumstance.
Yeah, I mean,
Does that make sense?
yes. How do we write this?
Who's our drafters? Justin and Ellen. Who's good at the language?
Looking at 1.4.
I'm looking at 1.5B13, which says like one of the factors to consider with respect to unconscionability is whether informed consent was given. So I think if we said here, like, that this would be a factor that you'd consider would be the fact that you did have the clients give informed consent to the fees. Like, we're not saying that you have to get informed consent, but it certainly is something that weighs in favor of conscionability and enforcing a fee agreement if the client agrees.
Well, let's back up to the beginning of the sentence.
Yeah.
Conversion clause is key to the acceptance or rejection of settlement offers are ethically prohibited except in the rare and narrow circumstances where, then we're going to talk about, so we're not really giving indicia, we're giving like requirements. So we can soften that formulation if we wish, but this one is like, they're prohibited unless bang, 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 bang. And do we believe informed consent is required? I mean, I'm comfortable with that, but I'm not sure others are.
I mean, we could end it, and you know, at the end of like, except in rare and narrow circumstances, and say sort of like some factors to consider whether this would be an unconscionable arrangement or something, and cite some of the factors and, or cite to 1.5B, or I don't know.
Yeah, so a period after circumstances, and then start factors indicating that such a conversion clause might be ethically permissible, include bang, 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 things like that.
I liked the unless we're uncertain of the factors.
Well, we're
Not
sort of,
always be rare and narrow.
it's not that we're making it up as we go here, but we are kind of treading new
Yes.
ethics territory. So I tend to prefer the formulation that Brandon just came up with. So that, you know.
I mean, but it's also like all basically like 1.5, when you look at those little factors there, right? They're basically, you know, which we could say whether, we could basically say it includes like that second one, whether it complies with rule 1.5, including or something, and then we could pull out a couple things that we think are significant.
Yes.
One of them could be the fact that there's informed consent or something. I mean, but each one of those is really a formulation. I mean, 2 and 3 are similar because you're still talking about 1.5, right?
They
Like,
are. I mean, you're right. The goals of the representation and alternate payment are agreed to in advance, clearly. That's factor 13 that you just talked about, right?
Have you looked at the Ramirez case?
No. Which case?
And the Ramirez versus Sturt event, that's the one where I'm just looking at it. I'm not sure if it applies, but it talks about where the lawyer and client agreed to a minimum settlement amount.
I think we actually did that might even be referenced in here,
Is
right?
it? Yeah, but it goes into whether or not it creates conflict of interest and a pecuniary interest.
Right.
And they say that it does, but so maybe that is helpful.
Right.
So we hold that whereas here there's evidence that a conflict of interest arose between attorney and client, which may have affected the ultimate settlement of the case. The settlement negotiations and settlement should be examined by an impartial tribunal to determine if the client's interests have been forcefully represented. In conducting that review, we place the burden of proof on the attorney to demonstrate that the attorney's own pecuniary interest did not interfere with the duty to promote the best interest of the client. And then it does talk about
That's
whether
interesting.
a conflict of interest. I don't know, I hope I didn't just derail the whole.
Well, no,
conversation, 'cause I was reading this.
in
and
the
like, this
very
was like-
first draft of this, we had a little bit of an exploration of 1.7 conflicts.
Yeah,
And I was unable to really rein that in, so I ignored it and focused on the rules that most of the other ethics committees in the country have hung this on. I don't disagree with you at all. I'm just wondering, can we get a clean enough result looking at, rule 1.2?
without having to go into 1.7.
Maybe,
Yeah,
yeah.
okay, sorry.
No, don't be sorry
No,
at all.
it's good to raise it. I mean, I also think this seems like one of those ones that we are gonna get hopefully a lot of good public comment that really can help us if there's some areas that are, I mean, we obviously want to put our best product out there right now,
Right.
but it will be,
I think we're gonna learn a lot from both.
we'll learn a lot.
Yeah.
But yeah, I think, I mean, where we're sort of going with this, I feel like we need to list it in terms of some factors and not as like a rule, because none of this, we don't like authority for these propositions. We want to make sure we have authority, obviously, for what we say, of course.
Right, so you don't want to present it as a conflict waiver situation, but you do want to make sure that the client gives informed consent to the arrangement, right?
Yeah, I mean, this is what's listed as like one of the factors to determine whether a fee is unconscionable, right? So I think that's sort of the backdoor, instead of saying it presents a conflict or otherwise, it's
Right.
just that it would be one of the factors that would weigh in favor of it being enforceable and conscionable, because, the client
Understood what was gonna happen.
what's gonna happen, and
Yeah.
a sophisticated client could very well do that in that hypothetical, one of the hypothetical here.
Well, you could just say prohibited except in the rare and narrow circumstances where the client's informed consent is obtained with respect to the goals of the representation and the alternative payment arrangements. And the other indicia of rule 1.5 are satisfied, or that it's not unconscionable under 1.5. Not otherwise unconscionable. It could be a simpler sentence, maybe.
Yeah, why can't we just take out instead of informed written consent, take out written?
Yeah, informed
That's
consent.
consistent with 1.1513. It says informed consent, and then it's got the asterisk to the definition, and doesn't that, we're clearly within authoritative and ethical bounds stating that.
So we would say, number one, the client provides informed consent to the goals of the representation and the alternate payment arrangement. And the operation, and then we skip all the way to 4, and the operation of the conversion clause under the circumstances is not otherwise unconscionable under 1.5. Is everything right? Maybe.
Well, I was looking at 3, but just keeping 3, but just taking out the written, but. The goals of the payment are clearly understood, agreed to in advance, that they've been committed, blah, blah, blah.
I mean, while we're on this too, I also just wonder if we want to take out that sentence, a conversion clause that interferes with the client's right to determine is ethically prohibited, because the footnote doesn't cite to authority for that proposition. The cases above it, you've already cited, and they establish the fact that that's improper in those circumstances. And then here we're basically this sentence after that is saying kind of the same thing, that they're ethically prohibited except in rare circumstances. So I think we need to take out that sentence above it.
The one that is followed by footnote 10.
Correct. Because when I saw that sentence, I was like, oh, it's citing to authority, and it's not, we're just saying something else about it being speculative. But we basically say the same thing in the next sentence. And we said, right, I mean.
Yeah, it doesn't work.
It doesn't work,
Doesn't work if we're saying that there's an exception.
right?
Yeah.
And then, and we've already, like, you guys, the citations, the cases above it are great, because it shows that the circumstances in which, you know, that matter and that cases have said that, you know, that's not proper in those circumstances, so that's good, but it just muddies it by that sentence.
So if that sentence is gone, we just need to,
Do we take out the thus, or does the thus flow from the next sentence? Or the new preceding sentence? Should we just say conversion clauses key?
Yeah.
yeah.
So,
What's in footnote 10? Because if we're taking out that sentence, we're taking out that footnote.
Anmaji, but I think we already cited and talked about Anmaji.
no, it's like just a commentary is what you 10,
Yeah.
which you may want in, it could be somewhere else.
Yeah. It doesn't need to be there. I probably put it there because I couldn't figure out a good flow. It's the sad result for many footnoted statements. You're right. So I agree. I think that should come out. And we should say, we just need to finish this end of this paragraph.
Yeah, and that footnote could be at the end of the paragraph, or we could just remove it.
Yeah.
That's my.
Could be at the end of that new sentence, just conversion clauses, key, blah, blah, blah.
Yeah. Yeah, I'm more comfortable with that formulation of the way we describe those like criteria, because, I mean, they are rooted in 1.5, but they're not, it's sort of an example of things that a lawyer could consider.
Do we need 2 and 3 anymore?
Well, yeah, wait a minute. 1, I'm still having trouble with. Agreed to in advance after having been communicated to a client that should
In a manner.
understand. Who's reasonably understanding?
Yeah, I mean, I think what I was proposing, and I'm sorry, I probably didn't finish telling, I was saying we could add,
That the client,
the client, to permit the client to make an informed decision regarding the representation. That's from 1.5 though, but that's whether we want to then say, we then talked about using an informed consent standard. So
Yeah, we could make clause 1 really short by just saying, the client provides informed consent to the goals of the representation and the alternate payment method.
Okay,
That means the same thing, right?
yeah,
So 1, yeah, the client provides informed consent to the goals of the representation and alternate pay. Okay, so after alternate payment arrangement, then can't we go all the way down to 4, delete everything between there and 4? I just don't want to repeat.
you're saying delete 3 and 4.
Delete 2 and 3.
Agree.
Yeah. Because I think, since we're talking about 1.5
Yeah.
generally, it's catching everything, is it not?
I think I agree, but I just will say, I don't love the formulation of 1. I
Okay.
like to have it on the burden being on the client, the lawyer to communicate. Or, I don't know, I don't I'm trying to think of the right formulation for that. But I agree with you that we don't need, I think we can just have those 2 factors if you want.
You want to say the lawyer obtains the client's informed consent as to, or? I don't know.
I like saying that the goals of the representation and the alternate payments are communicated to the client. And the lawyer is able to obtain informed consent or something like
No,
that.
that's fine.
I
Let's
just
work-
like
let's
to
just-
trigger the communication, because that's obviously a component of informed consent, right?
Yeah, but we're highlighting, which is great. So why don't you
I don't know.
craft that clause?
I'm not
Let's see if we
the
can
best
skip
on
to-
the fly clause drafter. That's Justin and Eleanor, I think, or other people.
And you saw the clause I drafted when I had plenty of time, so.
No, does anyone have an idea for that? For one,
How about taking what you had earlier, the goals? Where are we? I lost here. The goals of the representation and alternate payment arrangement are communicated to the client in a manner that should be reasonably understood by the client and confirmed by the client.
I mean, I like that.
That's fine.
Yeah.
Yeah,
And confirmed by the client, yeah.
Because I think then we're emphasizing that sort of duty to the, on a part of the lawyer to really communicate what's happening here as opposed to just quote unquote obtaining informed consent, which could mean here's a piece of paper and sign it, right?
Right,
Like,
right.
We want to emphasize the first part.
and confirmed, not informed.
Yeah, confirmed by the client.
Oh yeah, and then confirmed instead of informed by the client, sorry.
Yeah, so you have to take out the first clause right now in number 1.
Yeah. So right after the number 1, all the way to the first red line, the will delete. No, right,
Oh, sorry.
yeah, there we go.
Perfect.
But we have to have a capital the, right?
Oh, we've got no the, yeah, you're right.
I think it's in a manner that should be reasonably understood by the client.
Should be
A
reasonable.
B, but yeah, for should.
Yeah, then I think maybe 2 and 4 can go, 2 and 3 can go out.
Well, maybe we don't even need those numbers. Just have a comma or something.
Delete 2 and 3.
Yeah.
Yeah.
Because the, yeah,